5, 5, 1, 2, 3. 1, 2, 3, 4, 5. 156, 157.
1-2-3. Assalomu alaykum hurmatli mehmonlar. Barchangizni ikkinchi bora tashkil etilayotgan xalqaro yuridik forumda ko'rib turganimizdan xursandmiz. Avvalo barchani joylarini egallab olishlarini so'rab qolgan bo'lardik. Yana bitta iltimos, ahamiyat bergan bo'lsangiz, har bitta o'rindiqqa bir xil rangdagi niqoblar qo'yib chiqilgan. Aynan mazkur niqoblardan foydalanishingizni so'rab qolgan bo'lardik, chunki tasvirga olish ishlari ketyapti. Onlayn ravishda translyatsiya qilinadi. Bilamiz, tadbirning o'ziga yarasha estetik jihatlari ham bo'lishi kerak. Shuni to'g'ri tushunishlaringizni so'rab qolgan bo'lamiz. Bundan tashqari quloqchinlar bor. Boshqa tillarda bilamiz, sinxron tarjimalar bo'ladi. Kimga quloqchinlar kerak bo'ladigan bo'lsa, marhamat, bizni texnik xodimlarimizga murojaat qilib, hujjatingizni taqdim etgan holda uni ham olishingiz mumkin. Yana bir karra eslatamiz, o'sha tarqatilgan o'sha maxsus niqoblardan foydalanishingizni so'rab qolamiz barchani. Siz ham eslatib turing. Qarab kuzatib eslatib turing. Bo'ldimi? Bering. Joylarni egallatsa. Yana siz ham joyingizdan egallaylik.
Beş, 1, 2, 3, 4, 5. 1, 2, 3.
Qaytadan ichib ko'rdingiz.
5, 1, 2, 3, 4, 5, 1, 2, 3, 156, 157.
Hurmatli forum ishtirokchilari, bir necha daqiqadan so'ng forumimiz boshlanadi. Iltimos o'z joyingizni egallab olishingiz kerak. Maxsus niqoblardan, ya'ni maskalardan foydalaning. Sizlar uchun o'rindiqlarda maxsus niqoblar ajratilgan. Hurmatli forum ishtirokchilari, o'z joyingizni egallab olishingizni so'raymiz. Bir necha daqiqadan so'ng forum boshlanadi. Iltimos o'z joyingizni egallab olishingizni so'raymiz. Hurmatli forum ishtirokchilari, marhamat o'z joyingizga o'tirishingiz mumkin.
Дамы и господа, просьба занять места.
Assalomu alaykum. Assalomu alaykum xonimlar va janoblar, muhtaram mehmonlar va qadrli forum ishtirokchilari. Tashkent Law Spring 2-xalqaro yuridik forumiga xush kelibsiz. Mamlakatimizda 2-marotaba o'tkazilayotgan Toshkent huquq bahori xalqaro anjumanini biz boshlayapmiz va barchangizga ushbu anjuman muborak bo'lsin. Hurmatli xonimlar va janoblar, dastavval e'tiboringizga O'zbekistonda 2019-2020 yillarda huquq tizimida amalga oshirilgan tahliliy ishlarga bag'ishlangan, o'zgarishlarga bag'ishlangan maxsus videorolikni e'tiboringizga namoyish etamiz. Marhamat.
Вот на русском. Ты зачем узбекский забирал? Всё правильно.
Qonunlar inson organizmidagi qon tomirlari butun tana a'zolari bo'ylab
The laws are just human vessels.
bergani barobarida jamiyat ijtimoiy hayotining
They provide life to human body.
qoidalar bilan chambarchas bor.
And all aspects of our life are interrelated, closely interrelated with the laws, because society without law and state without society are both impossible.
Sohalar taraqqiy
Any sphere develops in its own by its own laws,
vaqtlar aniqrog'i
and as soon as laws are adopted, they are reflected onto human life.
qabul qilingan mana shunday normativ huquqiy hujjatlar
And recently, normative and legal acts were adopted, about 153 laws, 244 presidential decrees. And here I would like to mention that every normative document which was adopted is aimed at the improvement of the life of people and provision of rule of law. And of course, the basis for, and we have undertaken a great deal of effort in this regard, and the President has affirmed the concept on the improvement of so-called legal literacy, and a great deal of work has been done, and entrepreneurs have been provided a lot of opportunities and the ways to resolve their issues. During the last 2 years,
xorijiy sarmoyalar kirib keldi va investitsiyalar
4.2 billion US dollar of foreign investments were attracted to Uzbekistan. And here I would like to mention that in the condition of pandemic, the provision of people with jobs and support of entrepreneurship have become the priority.
jamg'arma tashkil etilib, buning hisobiga
And we have created special fund
asosan aholining ijtimoiy
for managing crisis situations, and they're firstly aimed at social protection of population and the support of those who suffered from the pandemic.
2019
And specific benefits were provided, or soft-term loans to entrepreneurs, and the tax burden has been decreased by 1.5 times. And VAT was reduced from 20 to 15%, and the presidential decree on additional measures to create favorable conditions for entrepreneurs, for businesses, and the elimination of bureaucratic barriers, and the prevention of red tapeism and administrative barriers in the provision of services, and elimination of obsolete procedures which are not in line with the current resolutions. And a great deal of norms and procedures have been simplified. 18 documents and licenses were cancelled, and the process of law creation has been also simplified, and the settlement of other relations have been improved in terms of conditions of more modern industry and implementation of, and the support of entrepreneurship were paid specific attention. and the system of public services has been revised, and of course the opportunities have been enlarged. And I would like to say that the development of legislative norms and normative documents became a part of electronic systems in the pandemic situations, and in such situations we managed to develop laws and adopt legal procedures, and it created the basis for ongoing continuous work in such a difficult time. And we also implemented the kind of guillotine for obsolete resolutions, which became a part of red tapeism and which created bars, and their number was decreased by 10%. And in general, the work which was undertaken in terms of provision of rule of law has become providing fruits, bearing fruits. And in the very beginning, if you remember, we compared society and laws with human body and human vessels. And this is the most important thing in our opinion.
Siz O'zbekistonda 2019-2020 huquq tizimida amalga oshirilgan ishlarga bag'ishlangan tahliliy video sujetni tomosha qildingiz. Hurmatli xonimlar va janoblar, endi forum yalpi yig'ilishining moderatorlik vazifasini bajarish uchun so'z O'zbekiston Respublikasi Adliya vaziri o'rinbosari Akbar Toshqulovga beriladi. Marhamat.
Assalomu alaykum, hurmatli forum qatnashchilari, aziz mehmonlar. Barchangizga tashkilotchilar nomidan forum ishiga va ishtirok etayotganingiz uchun minnatdorchilik bildirishga ruxsat berasiz. 2 kun davom etadigan Tashkent Law Spring ikkinchi xalqaro yuridik forumida yurisprudensiya sohasidagi eng dolzarb masalalar yetuk mutaxassislar ishtirokida muhokama qilinishi, forumning xalqaro miqyosdagi yirik muloqot platformasiga aylanishi hamda ishtirokchi davlatlar huquq tizimlarini rivojlantirishiga xizmat qiladi degan umiddamiz. Forum ishi bugungi pandemiya sharoitidan kelib chiqib, qatnashchilar onlayn va offlayn tarzda ishtirok etishmoqda. Forumni yalpi majlisda tashkilotchilar va hamkorlarimizning kirish so'zlari hamda faxriy mehmonlarimizning tilaklarini eshitamiz. Dastlab forumni ochib berish uchun so'zni O'zbekiston Respublikasi Adliya vaziri Ruslanbek Davletovga beraman.
So opening remarks, the Ministry of Justice will have the floor for now.
Barchangizga Tashkent Law Spring ikkinchi xalqaro huquq forumiga xush kelibsiz deymiz. Sizlar bilan yana bir bor ko'rishganimizdan juda ham
Dear ladies and gentlemen, colleagues and guests, foreign friends, I would like to welcome you to the second Tashkent Law Spring International Legal Forum. We are pleased to see you again. And taking into account the existing conditions this year, the forum is being held in a new hybrid format with direct national experts and remote participation of foreign visitors. I apologize in advance. I myself fell into quarantine and cannot participate on this spot, but all our team and organizers are at your service. This format corresponds to the main theme of the forum, Law 4.0, the vision of law in the age of the fourth industrial revolution. During the first industrial revolution in Great Britain, the movement of Luddites arose. Although the workers were breaking down the machines in the factories as they took away their job, but they didn't stop the technological progress. Subsequent industrial evolutions on the main chain reaction took place. Today, artificial intelligence and robotics, virtual and augmented reality, bio and neurotechnology, these latest methods are becoming a part of our lives right in front of our eyes. The World Economic Forum had predicted that most of the technologies of the fourth industrial revolution would become daily life routine by 2027. But in 2019, I recommended to create specific formulas for the mechanism to prognose future relationship 10 to 15 years from now, but no one in the world could imagine that the pandemic will become so global and will change humanity forever. The pandemic showed that not all sectors are ready to stand against this pandemics, and you know that the human predictions are nothing compared to nature. And the new environment significantly changes and very fast changes. It doesn't require just adaptations and provision of preparedness of legislations for future changes, and we need to fully support and fully follow human rights. International Human Forum Tashkent Law Spring is a unique platform to discuss modern trends and development of proposals with regard to further development of legislation. I would like to thank our guests for the interest they displayed in our forum, and we have collected with representatives from over 25 countries of the world and 20 international organizations. And with your permission, I would like to also mention the following things. First of all, it is always important to decrease those norms which leads to bureaucratic and corruptions. Very recently, we adopted a new law and which affirms things like the digitizations and the assessment of regulatory impact and public discussions, modern types of expertise and other novices. And the principle of guillotine started to work in Uzbekistan. And recently we have cancelled over 500 presidential documents. Another 400 presidential documents were on the verge of repeal. And the work in this regard will be continued. And the digitization of legislation is the most important and complex process because we have to think about over the questions how to use evolving technologies, whether they will break the existing rules and regulations and lead to the opposite results. A year ago, we introduced electronic development system in coordination draft legislation a year ago, and so far 1,000 documents have passed through these systems, and it was for the first time when we have received a departmental document for full electronic form. The second direction of this law is to make transparency an important element of the law-making process. Modern technologies create unprecedented conditions for the participation of various parties in a lawmaking process. In many countries, including Uzbekistan, there are special web portals for public discussions and of draft legislations. In general, this can be called a manifestation of direct democracy. However, unfortunately, the huge potential in this area is not fully used. Every stakeholder, whether business representatives, the scientific community, non-profit sector, or the media, should directly and actively be involved in lawmaking. Otherwise, a situation may arise in which the minority decides for the majority. In particular, some ministries and agencies try not to use public discussions to promote narrow interests because they know they will be under great negative criticism, which is why this mechanism is so important. Or it can be created by false impression, like manipulate public opinion by showing individual questions by a group of individuals, and if most of interest in solving small problems in a certain way. This is also an existing risk, and we must be prepared for all abuses, and the legal community must find an acceptable solution for the interaction with the public in the field of lawmaking. And the third direction, of course, is to improve the work of government bodies to ensure transparency. Artificial intelligence, digital platforms, cloud technologies, and various services, smart devices, create a new environment of virtual communication between the state and the society. Interactions are often made through social networks and technology platforms. A new form of communication between the state and the people is becoming increasingly popular. Practice shows that the most convenient form of communications between the state and the people is our country is by the means of mobile applications, and there is a big potential in this regard. It's kind of invisible states when in online regime you can solve any problem related to this state. And it is required to implement modern technologies which will increase transparency of public bodies' activity. Currently, the Ministry of Justice has developed a project, Open and Accountable Government, and submitted it to the government. The fourth issue is law enforcement. Nowadays, the scope of responsibility of the Ministry of Justice of the Republic of Uzbekistan has significantly expanded. Recently, in addition to studying law enforcement practices, we were giving the additional task of monitoring the implementation of presidential documents and orders. Such an integrated approach serves to improve the quality of lawmaking in the process of legal expertise. We analyze practices and risks that may adversely affect the implementation of legislation in the future. In this regard, it is necessary to invest in improving the skills of public sector and to establish contacts with stakeholders. The next issue about legal services. This area is becoming more common in electronic litigation, virtual review of cases, automated system of appointment of lawyers in criminal proceedings, remote training of lawyers, the use of electronic notaries and electronic digital signatures. We believe that the legal profession will change in the near future. Transformation is closely related to the automation in many processes. Therefore, it is necessary to prepare for mass retraining of personnel. As we expand our digitizations and as our place in virtual life grows, we will need to definitely need to take completely new approaches to protect personal data. By taking into account of data loss in large transnational social networking, it is not hard to imagine that how difficult this work can be. However, we have also seen in the registering the iPhone IMEI numbers show that there is always a strong need in such information. At the beginning of my speech, I started by talking about 19th century ludits in Britain, and even now there are similar hidden objections to digitizations, and this is specifically true for some officials and organizations that have learned to work in the past. Of course, not all organizations equally understand and accept the openness, accountability, bureaucracy, and corruption that society wants to avoid. They have not unaccustomed to these values. Digitizations and openness, on the other hand, require them to work in a completely new way. As much as transparency in public procurement, it is hurting these flaws, and if they don't change organizations, they won't justify public confidence, which will inevitably lead to them to crisis. Therefore, there should be a standard of transparency in every field, so that it's understandable to all, so that everyone who reads them could understand them equally. And second, there should be minimum requirements for similar digitizations and organizations that should be used with their minimal use of their programs, and the public should be also demanded. For Uzbekistan, it needs to prioritize digitization and transparency because there are many directions and many problems. And taking account the deficiency of resources, we need to define those directions which need to be financed and supported by the state. For instance, a new phase of transparency in the budget spending, especially current and road costs, should be shown on the interactive maps with specific addresses. Each organization's expenditures on repairs to its administration's buildings and information officials, real estate and vehicles should be disclosed. And another topical issue for Uzbekistan is to liberalization of agricultural relationships, since the huge resources of economy, public administration are directed to the agricultural sector. Поменялись они. This area is significant epoch on the Another very important issue for Uzbekistan is the liberalizations of relationship in agriculture, because a great deal of resources of public administrations are directed to the agriculture sector. This area has a significant impact on the development of all sectors, ensuring the rule of law in the country. And in this regard, investment attractiveness and the fair distribution of Uzbek lands is not only an economic issue, but also a huge socio-political issue.
Daromad manbai bu yer resurslari bo'lib qoladi. Shu bilan birga agrar sektorda rivojlantirish uchun qishloq xo'jaligi mahsulotlarini ishlab chiqaruvchilarning xo'jalik faoliyatiga ma'muriy aralashuvni to'liq bekor qilish, yerga bo'lgan huquqlarni barqarorligini ta'minlash, yer taqsimlashda aholining ishsizlik masalasini hal qilish nuqtai nazaridan kengroq qatlamlarga bo'lib berish, narxlarni shakllantirishda va moliya mablag'lari harakatida bozor mexanizmlarini joriy etish, yerlarning aylanmasi mexanizmlarini takomillashtirish, qishloq xo'jaligida qo'shimcha qiymat zanjirlarini yaratish bo'yicha ishlarni amalga oshirish zarur. Ko'p vaqtlaringizni olib o'tirmayman, hurmatli do'stlar. Bu murakkab inson munosabatlari qirralari juda ko'p. Yechilishi kerak bo'lgan jumboqlar ham shu jumladan biz huquqshunoslar uchun ham bugungi globallashuv jarayonida munosabatlar aholining davlatga, hokimiyatiga oshib borayotgan talabda namoyon bo'lmoqda. Bu esa davlat organlari ixcham va egiluvchan, byurokratiyadan xoli ishlashga majbur bo'ladi. Xarajatlarni kamaytirishga va samaraliroq ishlashga, oshib borayotgan ehtiyojga yarasha xizmat ko'rsata olishga undaydi. Barchasi esa huquqiy mexanizmlar, tartiblar va qoidalarga bog'liq. Bu borada huquqshunos o'rni va mas'uliyati alohida. Shunday ekan, ushbu jumboqlarni birgalikda yechish, o'ylash va tahlil qilish uchun birga yig'ilgan ekanmiz. Mazkur Toshkent huquq bahori forumi platformasida ochiq va konstruktiv muloqotga chaqirib qolamiz. Umuman 4-sanoat inqilobi sharoitida huquqiy institutlarga yangicha nazar tashlash va an'anaviy huquqiy mexanizmlarni yangi voqelikka izchil moslashtirish yo'llarini birgalikda o'ylaylik. E'tiborlaringiz uchun rahmat va forumning kelgusi sessiyalarida qiziqarli bahs-mavzularga tilakdoshmiz.
Rahmat. Forum ishtirokchilarini tabriklash uchun so'z navbati O'zbekiston Respublikasi Oliy Majlisi Qonunchilik palatasining spikerining birinchi o'rinbosari akademik Akmal Xalmatovich Saidovga beriladi.
Rahmat, muhtaram moderator, muhtaram vazir janob oliylari, bizning xalqaro hamkorlarimiz Matilda xonim, elchi McGregor xonimlar va janoblar. Men avvalambor mana shu an'anaga aylanib borayotgan ikkinchi Toshkent huquq bahori ishtirokchilarini mana shu tadbir bilan tabriklamoqchiman. Ikkinchidan, mana shu tadbirni tashkilotchilariga minnatdorchilik bildirmoqchiman. Yana shuni alohida ta'kidlash kerakki, bugungi tanlab olingan mavzu kun talabiga, zamon talabiga hamohang va yaxshi javob beradi. Mana vazir janoblari juda ham to'g'ri ta'kidladilar. 21-asrning mana 20 yili dunyodagi globallashuv jarayonlarining chuqurlashib borayotganligi. Globallashuvning asosiy ta'sirchan omillaridan biri bu 4-sanoat inqilobi bo'lib hisoblanadi. Insoniyat o'zini mana shu har bir taraqqiyot bosqichida turli xil mana shunday ta'sirlarga uchragan. Mana hozirgi kundagi shunaqa global tahdid va butun jahon tendensiyalariga e'tibor bersak, albatta bu raqamlashtirish. Raqamlashtirishsiz biz hayotimizni bugunini ham, ertasini ham tasavvur eta olmaymiz. Mana bu raqamlashtirishga umuman elektron hukumat, elektron parlament, elektron odil sudlovga o'tishga biz juda yaqinlashdik va aytadi-ku, bir narsaning, bir yomonning bir yaxshisi bor degandek, mana shu pandemiya sharoitida, pandemiya mana shu elektron boshqaruv tizimiga o'tishga katta turtki bo'ldi deyman. Bu masalan bittagina bizni parlamentimiz faoliyati misolida ham ko'rish mumkin. Biz tom ma'noda aytishimiz mumkinki, O'zbekistonda hozir elektron parlament tizimi shakllandi va shu fursatdan foydalanib Oliy Majlis deputatlari, senatorlari nomidan ham mana shu bugungi anjuman ishtirokchilarini qutlashga ijozat berasizlar. Endi aytishimiz kerakki, har qanday mana shu so'nggi 4 yilda O'zbekistonda yangi O'zbekistonning yangi qiyofasi shakllandi. Mana shu yangi O'zbekistonga mos ravishda yangi huquqiy tizimning asoslari qo'yildi yoki poydevori qo'yildi. Mana bu yangi O'zbekistonning asosiy me'mori, asosiy tashkilotchisi, asosiy g'oyasini olga surgan bu muhtaram prezidentimiz Shavkat Miromonovich Mirziyoyev bo'ladi. Men aytishim kerakki, mana men huquqshunos sifatida mana shu O'zbekistonda shakllanayotgan yangi huquqiy tizimning 5 ustuvor yo'nalishi prezidentimizning ma'ruzalarida, parlamentga bo'lgan murojaatlarida va qabul qilingan farmon, qaror va farmoyishlarda o'z aksini topdi. 5 yo'nalishda. Birinchisi, yangi O'zbekiston faoliyatining yangi huquqiy asoslari yaratila boshlandi. Hozir
in a new legal format in a new Uzbekistan, there are no entity that wouldn't have legal documents in this direction, if we talk about the state security, if we talk about internal affairs and all other entities, all of the legal frameworks being created, I don't want to provide any numbers, but one of the biggest our achievement is the creation, the codification of the legal aspect. During the Napoleon, he had 5 codex, and Uzbekistan have 18 codexes and or 18 codes, and we right now are working and developing new codes as well. So I consider that the new legal system is developing in Uzbekistan, as Mr. Minister mentioned, and we have a phenomenon of the legal guillotine. We didn't have it before. In France was the first one, 1861, passed a guillotine to the museum, and that's a tool cut a hat as a punishment, but and it doesn't provide a result as expected from the punishment, but we decided to cancel all of the legal documents, the legal acts that are useless in the life of the people. It should be, those acts should serve to help people. And all of those useless documents, legal acts, they've been cut through the legal guillotine. First is the developing of the legal the law, and a new concept was created in the legal sphere was created, and several institutional changes have been implemented as a new state authorities created. For example, the Center for Service Provided, Public Service Provided. We started with the 60, and right now we have 150 covering entire Uzbekistan, and this is one of the changes that we have in Uzbekistan. We can see in Uzbekistan, and all of this new initiative is spread out throughout entire Uzbekistan, including new regions. This is one of the institutional changes. The third direction is, as the President already indicated, we need to transfer attention. We need to pay a lot of attention to the legal sphere, and before, according to statistics, only 1% of all of the graduates from the university working in the area of the legal support and jurisprudence, and only 9% becoming students. in this profession. So this special speech, and the UN judicial reporter said that in his speech in Uzbekistan, we have 4,000 judges for entire Uzbekistan, and in my country, 2 million for each million people population. We have 2,000 judges. So recently we opened a new legal faculty under the National Guard, and was also implemented a revolutionary change in the preparation of the training of the legal cadre, and the cadre has the lack of cadre in the legal area create a lot of problems for the country. And yesterday in the legislative chamber of the Ali Majlis, we reviewed the area of education, and considering this event that we had, we can tell that this week is a really true legal week in Uzbekistan. We closed philosophy faculty that's been under the Academy of Science of Uzbekistan, and it was the end of the science. And the scientific work should be developing, should be creating, and the main goal of the legal area is development of the leadership, and for the state authorities. Tomorrow, prognosis and analysis tomorrow will be forgotten in Uzbekistan. So we created this special academy under the president as the Academy of the State that's conducting researches, and the next step is the creation of a legal improvement of the legal knowledge for the entire population of Uzbekistan. That's we have 35 million people living in Uzbekistan. We have to develop their legal knowledge, and if the population don't know their rights and duties, we shouldn't expect any development in the country. So we have to come up to the concept of the legal development culture. Legal culture development in Uzbekistan in the area of the international cooperation. Our president opened Uzbekistan to the world, and considering the legal sphere as well as the strategy of development of Uzbekistan, the fully comply with goals of the stable development, with stable development goals, and it's a fully localized option already created and using in Uzbekistan, and all of the measures implemented. As we already discussed, we just discussed with Madam Matilda Dimovska, all measures that we put in the SDG action plan cannot be accomplished without the legal framework, without the legal support, and it's also affecting a responsibility for the legal professionals of Uzbekistan. One of the main direction. Those directions that we already talked today. We're working and discussing extensively in Uzbekistan those directions and this work, and this It is a very important input for all of the other countries that participate in this event. As it was already said, as already mentioned, more than 25 representatives for 25 countries and international organizations participate in this forum today, and I would be glad if this event would be held in a open and a fruitful way. And I would like to express, and I would like to say the phrase from the Antoine de Saint-Exupéry: the most important is discussion. Thank you very much for your attention and for the fruitful discussion. Thank you for the short and you explain us in this brief that about the legal development. We wish you health, and the next word we provide to the honorable guest, the Vice President of the World Bank, Hanum, and she's going to talk on the and she's going to talk with us through the video.
Your Excellency, President Messi, Your Excellency, Deputy Prime Minister Khrushchev, Your Excellency, Minister Davletov, Your Excellency, Minister Ishmatov, distinguished speakers, good morning. Assalamu alaikum. I would like to extend my sincere gratitude for the kind invitation to participate in this important forum. The Tashkent Law Spring is an opportunity to promote dialogue and knowledge sharing in Uzbekistan and the region on the intersectionality of development, law, and justice. And this is particularly important in transition to a post-COVID-19 world. I am certain that these next 2 days will inspire many more transformations in Uzbekistan and in the region. And the World Bank looks forward to expanding its close collaboration with the government of Uzbekistan in helping it advance its reform agenda towards sustainable development. Last December, His Excellency President Mirziyoyev, in his remarks to the Parliament, reiterated his vision for Uzbekistan. More investments to eradicate poverty, more investments to improve the foundations for social protection, and more investments on the human capital front. The World Bank welcomes and supports the government of Uzbekistan's 5-year strategy for a stronger and more inclusive market economy. Since 2017, Uzbekistan has been undergoing many transformations in its development agenda, and we are pleased to be a partner in the sustainable and inclusive development journey. Our support of $7.2 billion in IBRD loans, IDA credits and grants, and a comprehensive program of analytical work and technical assistance is testimony to the important reforms the country is embarking on. And as the government of Uzbekistan and the region continue to make great strides in the development front, one must emphasize the importance of the justice sector in social and economic development. An effective and fair justice system is at the heart of inclusive development. It is also a key tool to sustainable recovery from the current health, social, and economic crisis. Strengthening the justice systems is also an essential building block to build citizens' trust in public institutions and social welfare, and the gateway to enabling the business environment which can promote investments and boost local economies. Sound justice systems help guarantee the fundamental rights of every man and every woman to live free of discrimination and inequality, and promote the protection of the most vulnerable. This is critical because when a nation builds systems and safeguards for the most vulnerable, it truly builds structure and opportunities that benefit all. And if you give me the opportunity, I'd like to give you an example. In the Olympics in London, my hometown, in 2012, the Olympic Park was built in a part of London in the north. And it was really incredible because when you went to the venue, there were no queues to really get in. And that is because it was designed for people who don't like queues, who maybe have an inability to stand for a long time. And what they did was they built the entrance to the Olympic Park around the whole perimeter of the Olympic Stadium. So you never had more than 2 people in front of you. Now, my daughter is autistic, and so she doesn't like crowds. This was perfect for her. So by building a stadium that actually was designed for those who were most vulnerable, like those who are autistic, actually benefited everybody because everybody got in really quickly. So when we build for the most vulnerable, we build for all. Worldwide, we have estimated that 5 billion people have unmet justice needs. This number includes, and here comes some statistics, 4.5 billion people who are excluded from the social, economic, and political opportunities the law provides. 1.5 billion people who continue to face justice problems they cannot resolve. And 235 million people living in extreme conditions of injustice without any form of meaningful protections. Quite hard-hitting stats. At the World Bank, we firmly believe that effective justice institutions are absolutely vital to achieving our twin goals of ending poverty and promoting shared prosperity for all. And the United Nations SDG 16 acknowledges that sustainable development cannot be achieved without peace, accountable and inclusive institutions, and access to justice for all. It is my favorite SDG. Without peace and justice, it would be difficult or virtually impossible to ensure equitable access to basic services, promote transparency and accountability, and ultimately eradicate poverty. In this way, the role of SDG 16 is unique. It is not only an outcome of sustainable development, but also an enabler for the achievement of all the other SDGs. It is a superpower SDG. We understand that Uzbekistan has identified the modernization of justice service delivery in high value priority in its governance reform agenda towards an open, transparent, and market-orientated economy. This will position Uzbekistan to converge with international standards and increase citizen and business trust in public institutions and services. Globally, the digital revolution has made information more accessible and affordable, transactions more convenient, and business scale-up more easy. This also helped promote inclusion and efficiency and foster innovation. We have also noted many gains in transparency and accountability, which help drive the adoption of technology-based reforms in areas such as public procurement, identification, financial services, amongst many others. With new developments in technology and a global pandemic which has forced the world to move to a more digitalized way of living, there really and truly is an opportunity to narrow the justice gap, and we mustn't let that opportunity slip through our fingers. The digitalization of court processes or case management systems has been implemented for years, and we are aware that more work remains to be done for this to be more inclusive, more efficient, and so it can be accessed by all. Technology is also helping make justice systems more efficient as well as accessible. People can now submit legal documents remotely and take part in virtual hearings. They can make electronic fee payments and process electronic filings. They can take part in electronic training and benefit from services of digitally enabled mobile courts. These revolutions are helping to bring legal services to disadvantaged groups or people closer to where they live and work. And at the World Bank, as articulated by the World Development Report 2021, Data for Better Lives, we are looking into how these changes can transform the justice sector. Through our newest initiative, the Access to Justice and Technology Project, we are identifying novel ways to understand how information and communications technology can best serve our goals of supporting countries to close the justice gap through a people-centered approach. Now, more than ever, as the world emerges from the devastating impacts of the pandemic, we ought to look into the importance of remote solutions to justice services. But we must be cautious. While technology offers new ways of solving old problems, it also introduces new risks. Among others, technology use raises privacy concerns and the risk of exclusion of the most vulnerable groups, the poor, women, and people with disabilities, who are often most in need of legal support. But they are also at a higher risk of facing digital exclusion. Rapid technology adoption without securing connectivity for all can ironically widen the justice gap. There's also a need to ensure that technology-based justice solutions consider the psychological and behavioral aspects of the public experience and their encounters with the justice system to ensure that innovation meets the needs of justice users. User-centric and human-centered designs therefore present an opportunity of ensuring that technology will eliminate and not create barriers to justice. To summarize, a reimagining of the legal architecture and interface requirements among all justice stakeholders, both within the public and the private sectors, is imminent. An important task is to explore and analyze what these differences look like. What are the implications for the legal profession? What are the implications for judges and justice officials, including prosecutors, court officials, forensic experts, notaries, bailiffs, and many, many others? And what are the implications for the citizens, businesses, and those most at risk of exclusion? Today, Uzbekistan is at a crossroads. To fully realize its potential, the government of Uzbekistan should continue making strides towards inclusive market economies that involve citizens and business communities. To achieve this, it needs to take more steps towards diversifying the economy, increase productivity and competitiveness, continue to improve the public and justice sector governance, promote inclusiveness and human capital development, address climate and environmental degradation, tackle inequality, and, of course, reduce poverty. I'm confident that this forum can provide a supportive structure for justice sector policymakers. This will help participants learn from one another and strategically deploy digital technologies alongside institutional and regulatory reforms for effective justice sector performance. Since good dialogue and strong networks emphasize joint value creation, the World Bank is very pleased to participate in these efforts in collaboration along with other development partners. So, thank you again for your kind invitation to be here. I wish you all a very successful conference. Goodbye.
Sendi Akaro xonimga o'z minnatdorchiligimizni bildiramiz. Chunki Jahon banki O'zbekistonni eng katta iqtisodiy rivojlanishga hissa qo'shayotgan xalqaro hamkorlarimizdan biri hisoblanadi. Shuningdek, nafaqat iqtisodiy jihatdan, balki institutsional
So for the cooperating organizations,
honored to be speaking here today. My colleague, Minister Edwin Tong, took part in the first edition of the forum in 2019. Given the time available to us, I'll just share a couple of points on the rule of law. There has been tremendous change around the world, how we live, work, interact with each other. Work can be done from anywhere. And people in different countries can meet at any time, like what we are doing now. On the whole, tremendous benefits have come through technology and connectivity. But the same connectivity and technology has also enabled crimes to be committed across jurisdictions. How can we make sure the rule of law works in the face of the challenges brought about by these changes? We will need new solutions, a greater understanding between states on issues like what national jurisdiction means in such an interconnected world, the impact on which laws apply and how, for example, criminal laws as well as, in a different context, laws relating to taxation, the way in which business is done across international frontiers and how companies account for that. A second trend is that many more countries are taking part in the international system. We have a much more multipolar world. At the same time, we can expect that we will see more frequent pandemics, health crises, economic crisis, which spread across the world. How can we create a rule-based order in this international context? How can we better harmonize our laws, at least in the areas where we interact? Which organizations can coordinate these? These are some of the questions. I'm not suggesting any solutions. I think the international community has got to start thinking about these questions. Thank you.
Shanmugam janoblariga o'z minnatdorchiligimizni bildiramiz.
We are very thankful to Mr. Shanmugam, and we have established very good links between the Minister of Justice and your country, and I guess we will only enhance our links. And we have another distinguished guest, Director General of World Intellectual Property Organization. So, Mr. Tang, the floor is yours. Уважаемые господа, ваше превосходительство, господа министры, дамы и господа, и мне очень приятно принять участие во втором международном юридическом форуме Tashkent Law Spring, где нам предоставлена замечательная возможность рассмотреть вопросы, связанные с правами интеллектуальной собственности. И первый форум в 2019 году зарекомендовал себя как важную платформу, где обсуждаются важные междисциплинарные вопросы в сфере развития юридических и правовых механизмов. И четвертая промышленная революция весьма своевременна, она очень ценная для нас, и она действительно предоставляет возможности для обеспечения дальнейшего роста экономики.
Significant changes we have observed in recent years at WIPO has been the globalization of innovation. 7 out of 10 of IT filings now originate from Asia. 6 out of 10 R&D dollars are now spent in Asia. And Asian-based innovators found more than half of all international patent applications before WIPO for the first time in 2018. And this trend has continued last year. WIPO's Global Innovation Index 2020 has identified countries like China, India, Republic of Korea, Malaysia, Singapore, and Vietnam as global innovation leaders. Uzbekistan itself is ranked 4th amongst the 10 economies in Central and Southern Asia. It is therefore timely and important to hear the voices of IP academics, researchers, jurists, and lawyers from the Asian region. While the global COVID-19 pandemic has caused much disruption and hardship, it has also accelerated many trends that are friendly to innovation and friendly to technology. Economies and enterprises have shifted to digital ways of working, and this will hasten the speed at which IP and other intangible assets like data, know-how, expertise are moving to the center of our economies. To facilitate this transition to innovation growth, it's important to take an ecosystem approach. IP laws are key to our success, and they are foundational, and it's therefore important that good ideas are protected by IP. But this is only part of the journey from an idea to the market. For the IP right to become more than just a legal right on a piece of paper, it must transform into an actual product or service in order to bring it to life and to make a real impact on the country and on the people in the country. Therefore, we also need to work to build the right capabilities, mindsets, and elements to facilitate the translation of IP into products and services, and ultimately jobs, business growth, and economic development. Governments will also need to look into creating the right elements for R&D commercialization, IP valuation, IP financing, and IP dispute resolution, including arbitration and mediation, to take place, so that IP laws can flourish and come to life within a larger dynamic innovation ecosystem. Uzbekistan has made important strides in building an innovation ecosystem and is now poised to take advantage of the fourth industrial revolution as an engine of growth. Your country is a strong manufacturing environment populated by companies in the fields of automotive, machinery, chemical industry, and transportation services. Manufacturers in Uzbekistan have already started to widely deploy robotic, flexible systems to tackle complex assignments. For example, in the vehicle plant in Asaka, line tracking robots have already been introduced in the assembly line. But to fully leverage the fourth industrial revolution for growth, we must be prepared for the convergence of different industries. The automotive and the manufacturing industries will increasingly be converging with AI and data-driven industries, and leveraging on these trends for long-term growth will require a multidisciplinary approach. It will require the expertise not just of legal experts, but those as well from other fields, such as economics and technology, to come together, debate, discuss, plan, and execute. WIPO stands ready to support Uzbekistan on this challenging but exciting journey, and in line with the precedent of Uzbekistan's approval of measures to strengthen its IP system, WIPO will also assist Uzbekistan in the development of its national IP strategy and in the implementation of other IP-related projects. In this respect, we're working closely with the IP agency under the Ministry of Justice to support the creation of an IP ecosystem in the country and ultimately assist in the development of Uzbekistan's future economy. Once again, it is a pleasure to address this forum. I wish all of you every success, and I congratulate Uzbekistan on the organization of this important event. Thank you very much.
Katta rahmat O'zbekistonda shu
Thank you very much. So the next floor is given to the President of the Venice Commission, Mr. Gianni Okocha.
Good morning, dear Mr. Davletov, dear ministers and participants of the forum. It is a pleasure to address you on the occasion of this second legal forum, Tashkent Law Spring. We are having this exchange under very particular circumstances. Regrettably, the coronavirus pandemic still prevents us from meeting in person, but I'm sure that this will not affect the quality of the discussions and the impact of this event on the reforms planned and successfully carried out in Uzbekistan. As you may know, the Venice Commission is an expert body of the Council of Europe composed of independent experts chosen by its member states. Memberships stretches beyond the European continent. The Commission is a so-called enlarged agreement where all the 47 Council of Europe member states are, and currently 15 non-European countries sit as peers, including Kazakhstan and Kyrgyzstan. Moreover, in recent years, the Commission acquired the possibility and the means to cooperate and share its unique experience with many other countries in the framework of the targeted projects, and I'm glad that Uzbekistan is one of them. In this respect, I would like to use this opportunity to thank the European Union for its financial support, which makes this cooperation possible. Ladies and gentlemen, this second forum will address a broad range of issues. Without entering into all details of this very rich program involving many eminent participants, I would like to underline several topics which are of particular interest to the Venice Commission. First, our debates will address the legislative process, or more specifically, how to draft good laws. This is an issue on which I recently had the honor to intervene in a seminar organized by the German presidency of the Council of Europe. Once again, I take the opportunity of today's conference to insist on the importance of the respect of the rule of law, as developed in the rule of law checklist drafted by the Venice Commission. The rule of law first implies the principle of legality, and in particular, that draft legislation is publicly discussed, implementable, and duly implemented. It also includes, in particular, legal certainty, that is accessibility and enforceability of the legislation, which must be written in an intelligible manner, and stability of legislation. In order to create a proper environment for public discussion of draft legislation, the accessibility imperative implies that legal texts are easily accessible, in particular, free of charge on the internet. I would add that access must be possible to consolidated text and not just to a basic law and amending acts. The predictability imperative means that the wording of the law must be sufficiently precise and clear to allow subjects of law to regulate their conduct in accordance with its rules. Added to this is the requirement of stability and consistency of the law. Repeated and fragmented amendments can make a legal text lose all coherence. I'm looking forward to the debates on these important topics, which I'm sure will be addressed at specific sessions of the forum, notably of those devoted to the implementation of a unified state legal policy and to the use of the new IT tools in this process. The second area of interest to the Venice Commission concerns the judiciary and the opportunities provided by the new technologies. At the European level, the recommendation of the Committee of Ministers of the Council of Europe on judges' independence, efficiency, and responsibility encourages to promote electronic case management systems and information communication technologies, both by authorities and judges. However, unfettered use and access to digital information could put at risk the core values of judicial independence and impartiality. New technologies, as well as the dramatically increased availability of information of all kinds and quality, could have a distorting effect on the judicial process and on its outcomes. Therefore, it is of primary importance to identify the broad issues that emerge from the growing use of IT tools and to provide for an appropriate regulation on the level of law of the way these new methods are used. Ladies and gentlemen, I think that we all agree that even the best quality legislation is useless if individuals are not informed about the applicable rules and that the latter are not properly implemented. This brings another issue which is on the agenda of this forum: how to ensure the openness of the public authorities and find an appropriate model of interaction between the administration and the public. Access for citizens to information held by state bodies is a fundamental right and is part of the freedom of expression and information. To the freedom of expression and information corresponds the obligation of the state to refrain from actions which obstruct it. To the right of access to information corresponds the obligation of the state to provide for the access to it by law. When we talk about the openness of public authorities, we mean open government, which implies that public processes are becoming more transparent. Public information is available online, and citizens and non-governmental organizations not only have access to specific IT tools, but are also encouraged to interact with the public administration on a broad range of issues through new platform-based forms of participation and collaboration. Mr. Chairman, I hope that this second forum will be beneficial for our common action, and its recommendations proposals will be duly taken into account during different activities that we prepare in 2021, notably in such areas as improving the quality of the lawmaking process, reinforcing the independence and impartiality of courts, and supporting administrative reforms. I wish you a very fruitful debate in the framework of this second Tashkent Spring Forum, and I'm looking forward to strengthening our future cooperation. Thank you very much for your attention.
Katta rahmat Venetsiya komissiyasi tomonidan bugungi forumimizda.
Thank you so very much. Now we are grateful to representatives of the Venice Commission for their opinion, for the ideas suggested by our colleagues, and definitely the activities under our forum definitely will be enriched by the opinions of the representatives of the Venice Commission. And now I would like to give the floor to Mr. Ayan Bingle, representing the another international organization.
Thank you. Minister Davletov, distinguished delegates. As the Director General of the International Development Law Organization, the only global intergovernmental organization exclusively devoted to promoting peace and sustainable development through the rule of law, it is a pleasure to join you today at the Tashkent Law Spring. This year's theme is both timely and relevant to the extraordinary period of transformative change we are all currently living through. COVID-19 has shattered the status quo and is transforming the way we live and work. Social and technological change often outpaces legal reform. We are seeing this play out in real time with the ongoing digital revolution, and the law must, of course, catch up. But even more fundamental, in my view, is the emphasis on the vision of the law. It reflects the stark choices we face as individuals, as societies, and collectively as one human family about the kind of future we want to build as we recover from this crisis. Because ultimately, the law is an instrument that expresses and seeks to advance society's fundamental values and aspirations. It can be an engine of empowerment and progress, but as we have seen many times in history, when misused, the law can also be a tool of oppression. The concept of justice, and in particular, the elements of due process, equality, non-discrimination, good governance, and respect for human rights, is what distinguishes the rule of law from rule by law. It is this vision of law that IDLO works to advance in over 30 countries in all regions of the world. We have been active in Central Asia since the early 1990s, initially supporting the transition to market economies with legal frameworks and capacity building. Today, IDLO implements nationally owned programs to advance justice sector reforms, promote greater access to justice, and support sustainable economic development. Our partnership with Uzbekistan started in 2018, and I was pleased to sign a memorandum of understanding with Minister Davletov very recently. IDLO looks forward to further strengthening this partnership and to contributing to the ongoing legal reform process. The COVID-19 pandemic has wrought huge suffering, exacerbating pre-existing inequalities and fault lines in societies all around the world. Over the past year, IDLO has been working with our partners to put the rule of law at the heart of the global response to the pandemic and to promote a more just, equitable, and sustainable recovery. Allow me to share 4 insights from these efforts. Firstly, Innovation and technology have enormous potential for ensuring justice for all, not just a few. Even before COVID-19, more than 1.5 billion people had a justice problem they could not resolve. For many, barriers include lack of awareness of their rights, not being able to physically access a court or pay for legal services. And while COVID-19 laid bare the consequences of years of underinvestment in justice systems and widened the justice gap, it also challenged us to innovate, reimagine, and explore alternative approaches. It is an opportunity to reimagine more people-centered justice systems based on a clear understanding of justice seekers' needs. Digital innovations, including emerging technologies such as blockchain and artificial intelligence, can be a great equalizer. They have tremendous potential to radically expand access while also increasing cost effectiveness, transparency, and accountability, and provide greater legal clarity and certainty. IDLO works with justice institutions around the world to develop context-specific and nationally owned approaches to integrating digital innovation and tools. Just today, we were honored to receive the first USAID Digi Award for our work to support the Kurd judiciary to implement a holistic e-justice system and make judicial decisions publicly available. Alternative dispute resolution mechanisms can also play an important role in expediting dispute resolution and reducing the burden on courts at a time of increased case backlogs. On this note, I am pleased to share that in partnership with the Uzbek Ministry of Justice, we are launching a new project to support commercial mediation and online arbitration for dispute resolution during the pandemic. But we must ensure that the implementation of these approaches is equitable and inclusive and does not create new forms of discrimination. And this brings me to my second point, which is that the law must prioritize the needs of those who have been worst hit by the pandemic, particularly women and girls. IDLO's report, Justice for Women Amidst COVID-19, developed with partners including UN Women, UNODC, UNDP, and the World Bank, shows how the crisis is threatening to roll back decades of hard-won gains on gender equality. The dramatic rise in intimate partner violence during times of lockdown is a clear example. IDLO has adapted its work on combating gender-based violence to address the increased demand for support and services for survivors. In Afghanistan, for instance, we have been supporting women's shelters, which saw numbers of survivors seeking refuge double in some cities. Thirdly, the law can help rebuild trust in governments and public institutions. Rebuilding people's confidence in government was highlighted as a major challenge by global leaders in the UN's 75th anniversary declaration last year. A major source of lack of trust is corruption, which diverts funds from essential services and initiatives, undermines confidence in public institutions, and is a major impediment to sustainable development. COVID-19 has dramatically aggravated both the scale and impact of corruption as countries mobilize and disperse significant emergency relief and recovery funding. The law can be a powerful tool in the fight against corruption. IDLO is working in countries as diverse as Armenia, the Bahamas, the Philippines, and Ukraine to strengthen the ability to investigate, prosecute, and adjudicate offenses related to corruption. We have also engaged with the preparatory process for the General Assembly's special session on anti-corruption and the G20's anti-corruption working group to support a multilateral approach to address this global problem. Fourth and finally, we must build a legal infrastructure to tackle our shared challenges. We really are all in this together. The pandemic itself and long-term threats like climate change do not respect national boundaries. Today, the 2030 Agenda for Sustainable Development represents both humanity's highest aspirations and an effective roadmap for recovery. And the law is critical to accelerating progress on both peace and development. Many SDGs implicitly draw on principles of inclusivity, equity, and non-discrimination, and require the creation of new legal frameworks and institutional capacity for their implementation. Effective laws and institutions can promote inclusive economic recovery, strengthen pandemic preparedness and response, and help us transition to a greener and more climate resilient development model. To conclude, there is tremendous scope to learn from experiences and expertise across the world, and to use this knowledge to realize the vision of a world where everyone lives with dignity and equality under the rule of law. It is in this spirit of both urgency and optimism that I look forward to the discussions at the Tashkent Law Spring. I also invite you to continue this discussion at the SDG 16 conference IDLO is co-hosting with United Nations DESA and the government of Italy next week. It will be an opportunity to take stock of how goals related to peace, justice, and inclusion have been affected by COVID-19, and to explore ways to accelerate progress on SDG 16 and the entire 2030 agenda. I hope to see you there, and I wish you all the very best in your deliberations. Thank you.
Katta rahmat Begil xonim bildirgan fikrlaringiz uchun.
Thank you very much. We are so very much thankful for your presentation, and it was a great pleasure for us to listen to you. Within the framework of this activity, within the framework of this forum, we will continue our collaboration to achieve the objectives that we have. And we would like to pass the floor right now to our partner and also co-financing partner, representative of UNDP, Res Rep of UNDP, Mrs. Dimovska. Please, the floor is yours. Good afternoon, distinguished participants. Мне бы хотелось начать с поздравления. Узбекская кабина, русский канал, отдайте. Industrial Revolution. Поскольку мы сейчас с вами говорим о настоящей индустриальной и промышленной революции, мы обсуждаем с вами вопросы, которые действительно касаются всех нас. И мы говорим также о будущем нашего мира. Только сейчас мы принимаем решения, только сейчас мы соответствующим образом стараемся выйти из пандемии COVID-19. Эти выборы очень серьезно зависят от того, как новые технологии и новая революция в промышленном мире будет соответствующим образом реализовываться и как мы сможем четко определить дальнейшие шаги. Именно это определит успех нашей страны, и это
United Nations Development Program is working in many countries on digitalization, and we have seen how important it can be to advance the human development in general. On a personal level, we also have seen the impact of the new technologies in our behavior even. 10 years ago, I was not sitting with this telephone next to me, and we have not been connecting in that manner. But the point is that the changes that the new technologies will be bringing to the economy, to the society, to our behavior interactions will be even much more in the future. So, and that we will feel irrespective if we live into and sit into a developed or developing country. So the whole world is impacted. Now, the point that I wanted to make, the key is that the fourth industrial revolution brings a lot of opportunities, but also it comes with the risks and the challenges where the role of the government and the legal system and institutions will be extremely critical. I think many were mentioned. I will flag only a few examples. Technology can accelerate development, as we said, but without a clear legal and people-centered legislative framework, that can bring a risk. It can bring a risk that the power and the decisions are made by the owners of the technology and the technology itself, and therefore leading to deepened inequality, digital divide, and further strengthening of fragmenting of the societies. And here comes the issues of personal security, data privacy, freedom of choice and expression that can be put on risk. We all know that certain jobs are put at risk with the new technologies that are coming, with the automation in particular. The recent study of UNDP and Economist Intelligence Union says, in fact, estimates that percentage for Uzbekistan is 55 of the jobs being endangered by the new technologies or will be subject to changes. We have seen artificial intelligence automation have a huge implication into the public sector. New technology-driven services can be the core of the future health system, for example. But also it can come with the risks. If, for example, ethnic biases or gender stereotypes are included into the algorithm-based public services, that can be a risk that it brings the kind of the risks from the biases from the past brings into the future. So that's another one. The revolution may bring new kinds of public services, but also how they are administered. The futurists are noting, they think that perhaps the court cases can be resolved even without the cases being opened. In the future, even without cases being opened into the courts, or even that the judges may be replaced by the artificial intelligence. McKinsey estimates that 20–30% of the work done by lawyers will be automated in the future. Now, what does it mean to us? What's the way forward? I think we need to understand. The most important point is one needs to understand, to be prepared, and then the key question is to which ends will the new technology will be deployed to, and what will be the action, how we will mitigate the risks and the challenges that come from the new technologies. And here comes what has been already mentioned, the SDG 16, the one that is the enabler of all others, or enabler for our future development. And that is when we talk about effective governance, rule of law, anti-corruption, protection of the human rights, and transparency. Now, I don't want to take too much role, but here on this point, I think we are gathered around that. So the legal industry will have a significant and important roles. And I am here encouraging all of those part of the legal industry to take it. For example, the legal industry will have to be fully aware of the potential implications and what are the trends, so that we come with a new narrative that will work towards a people-centered development. Second, agile institutions, we have seen how agile institutions were able, technology-powered institutions were able to respond during the crisis. So the challenge for the future will be how to use even more those tools. And it was already mentioned, the Minister of Justice made examples of how such tools were already deployed in Uzbekistan. But of course, as those evolve, much more needs to be done. For example, the application of artificial intelligence and blockchain to reduce the court backlogs and many, many more. Now, the third point is that the new technologies also bring opportunities for more openness, for more transparency, for more accountability. And here comes the potential for the Parliament outreach to its constituencies in all its functions, or the transparency in the budgeting processes. However, here the intellectual property patents and antitrust law and other laws will be extremely important. The fourth point I wanted to make is about we have seen how the digitalization lately globally could be used to feed misinformation and hate speech even. So these are the issues that are extremely important as they intersect with the human rights and the freedom of expression. And finally, the implication or the reflection of the education system and institutions to make sure that the curricula in the law universities are adequately prepared for the lawyers or the legal professions, for the agile to the fourth industrial revolution. So I finish by encouraging all legal professionals to look into this issue, to adapt the opportunities of the fourth industrial revolution and institutions, of course, not for the sake of pioneering the new technology, but for the sake of helping the country and the people moving forward in a fair, more fair and sustainable world for Uzbekistan and for its people. Thank you very much. I hope that these topics will be addressed during these 2 days. We look forward on working on these matters further. Etin Buringis, uchun katta rahmat.
Katta rahmat Dimoska xonim.
Thank you so very much, Mrs. Dimovska. Thank you. We truly are quite sure that we will be able to discuss all these matters, and probably right now, currently, we will be able to discuss it as well. So everything that has been already thought about, and when we were discussing the fantastic future that we have, the matters of automatization and the process of digitalization is ongoing, and I agree completely with you that we have to be ready for that, and that plays quite an important and paramount role in our national development and in our progress. Our next speaker of today is our partner, Mr. McGregor, Project Coordinator of OEC here in the Republic of Uzbekistan. Ladies and gentlemen, good afternoon, good morning actually. I would like to express my deepest gratitude on behalf of the OEC Office of Project Coordinators to be part of this great forum, and I would like to welcome all our participants, which is, and that forum is of a great importance, and the topic of our discussion is very important. We truly think that this very historical event, not only for Uzbekistan, but for all of us, taking all that into account, we would like to emphasize that we are right now thinking and discussing the future of the Republic of Uzbekistan. Uzbekistan cannot live without resolving all these important matters. So I have the great honor working in Uzbekistan for several years already. And of course, on behalf of the OEC project coordinators, I would like to emphasize that the role of the Republic of Uzbekistan is very much important. And within the framework of our collaboration, we were able to achieve a lot of objectives that we had to share. And I'm very happy to be here with you and apply all these obligations and commitments. The action strategy that has been adopted for the 5 years in the Republic of Uzbekistan truly reflects all the OSCE commitments and truly meets all the requirements of European Union as well. So within recent 4.5 years, all the reforms and changes which are rapidly going on in the Republic of Uzbekistan, we welcome them. And I became an eyewitness of those changes which are happening in Uzbekistan. All these joint efforts and activities which we are implementing together in collaboration with Uzbekistan. This is just another useful area of our collaboration, which is quite constructive for the Republic of Uzbekistan, and not only for that. So we are happy to continue this collaboration, fruitful collaboration with the Republic of Uzbekistan. We would like to assure you that all these measures will be further implemented in partnership with OSCE. That supports, once again, our commitment, our partnership and collaboration. All the citizens, nationals of the Republic of Uzbekistan, all the partners and donors in the Republic of Uzbekistan, we have to work together to achieve the objectives that we have. We share interests, and right now I'm switching to English.
Continue in English. This is the second Tashkent Law Spring. Why are we here? It's about rule of law. It's about justice. And why do we need to worry about rule of law and justice? Okay, I've just talked about OSCE commitments. Yes, there's OSCE commitments relating to that, so that's why I'm here. But why is it important for the people of Uzbekistan? Well, I don't need to tell you myself. I can use the words of His Excellency President Shavkat Mirziyoyev, starting with the 2 speeches he gave during the month of December in 2016. And during that month, he very clearly laid out the reason, well, one of the big reasons, but one of many, that rule of law is so important. Because we all know that we want to improve the economy of this country. We all know that by doing so, we lift the people out of this country up economically. But you can't just press a button and make that happen. You need rule of law. It's a critical, important part of the economy. And the president said there's a relationship, a correlation between rule of law and economic growth. And as I said a few minutes ago, we've seen a lot of progress in the last 4.5 years, a tremendous amount of progress in rule of law and the economy. If you look at figures from the World Bank, those figures will indicate that last year, the year of 2020, Uzbekistan was one of the only nations worldwide that had an increase in GDP in spite of the pandemic. Western European countries down 20%, 30% GDP. North America down similar numbers. All over the globe, countries took a dive in GDP because of the pandemic. But you know what happened here? The economy of Uzbekistan proved resilient because rule of law has increased. That in turn has brought foreign investment into this country, created jobs. We need to think back to what things were like 4.5 years ago and realize how much better things are. But there's still more to be done. The president, again, I'm going to borrow some words from the president. He said, every courthouse in Uzbekistan needs to be a place where the people of Uzbekistan can observe that justice happens in that courthouse. Everyone, not just here in Tashkent, not in the big cities, but everywhere where justice is supposed to be practiced, it is for everybody. You know, there's a technical term we use in the English language in discussion of law. We call it the equality of arms. And equality of arms means that those in authority have resources to legal professionals to help them do what they need to do, but at the same time, everybody has access to those same legal resources. So that means those who are practicing as lawyers for administrative bodies have good resources, but those advocates who practice and represent normal people, entrepreneurs and others, in their difficulties with the legal profession, they also have access to those same resources. And laws are created, written, and practiced with that in mind. If we believe that rule of law is critical to the growth of this country, if we believe that justice needs to be practiced every day, then not only do we have to improve the legal culture, which we are doing, which is happening, but we also must give everybody in this country access to legal information, legal resources, and legal professionals when needed. Because it is those resources who will in turn allow entrepreneurs to flourish, to build the economy, to help their fellow citizens, and to attract foreign investment. This is what we can do. This is the result of practicing justice, increasing rule of law, and this is the biggest reason why I am so pleased that the Organization for Security and Cooperation in Europe is supporting this Tashkent Law Spring. This is a unique gathering. This is only the second time we've done it here, and I hope there are many more to follow, because this is one of the most important things that we can do as a society, as a people, to help ourselves. We heard right at the beginning that the pandemic has shown some weaknesses that we have. Let us hope that the dialogue today and tomorrow will help us find ways to deal with those weaknesses. And I will close with a small personal note. This event, is my last official event as the OSCE project coordinator in Uzbekistan. It's been the greatest honor and privilege of my life to be in this country, working for the OSCE in the position that I have during this historic time. And I wish for all people of Uzbekistan the best possible future and good health and happiness and great success. Thank you very much.
Janob McGregor uzundan uzoq qarshi olyapti. Sizni
Mr. McGregor. So, you are a model diplomat, and your achievements in enhancing cooperation with Uzbekistan are highly appreciated, and your love for Uzbek language Well, we will also remember wishing you every success in your further activities. And now we would like to give the floor to Lord Chancellor and Secretary of State for Justice, Dr. Honorable Robert Buckland.
And everyone involved in organising the event for inviting me to speak. I'm really pleased that despite the restrictions placed on all of us by COVID-19, technology enables us to continue to meet, to make the best of this opportunity to engage with each other, to learn from one another, and to build upon the strong relationships that already exist between us. Now, the fact that we are meeting virtually makes today's topic, the vision of law in the age of the fourth industrial revolution, all the more apposite. Without wanting to simplify it too much, I think it's fair to say that law tech is the future for legal services and justice systems worldwide. It is a process that we have already seen play out over the last decade in the financial services sector, as fintech and regtech have grown globally at an exponential rate. Law tech is going to have the same effect on the way that legal services across the world deliver timely and effective justice to individuals and businesses alike. Now, we need to be ready, and I think that the UK is uniquely positioned to work with our partners around the world to prepare. Now, as you know, English and Welsh law is renowned for its age-old traditions. Now, I say this as someone who, as a barrister, as a part-time judge, and now as Lord Chancellor, has found that my wig and gown have become ever more elaborate with every new role. But traditional dress is, of course, about more than appearances. It's a symbol of the rule of law and of our common law system, which has evolved over centuries to meet the needs of the people that it serves. That adaptability is another hallmark of English and Welsh law, and one of its many strengths, which is something that will no doubt be covered in the panel happening tomorrow, where a number of experts, including my ministerial colleague Lord Wolfson, will talk more about the features of English and Welsh law. Now, change is of course necessary if the law is to maintain its relevance and its importance as one of the cornerstones of a modern society. In the fourth industrial revolution, one of such scale and speed, this is more important than ever. Courts and legal professionals across the world are already trying to adapt to innovation and technological advancements which are fundamentally changing the way the law is practiced. The UK's legal sector is already championing the kind of innovation that will characterise the law in the future by driving forward and developing new technology that can accelerate the delivery of global legal services. Together with Tech Nation and the Law Tech UK panel, we funded and developed Law Tech UK, an initiative to help to transform the legal sector through technology. Law Tech UK has a comprehensive work programme that builds on the many initiatives that are already going on in the sector, and which includes a law tech sandbox where innovative ideas can be tested in a safe, government-backed space. Law tech is an area where there is significant scope for international cooperation, and I hope that today will be one of many conversations on how we can integrate new technologies in the interests of justice and the delivery of legal services in the future. We are living through a period of unprecedented globalisation, and the law is certainly no exception to that. The legal services market is estimated to be worth around $728 billion US, and everyone wants a piece of the pie. As the legal services sector increasingly operates within a global market, it is important we all make the most of every opportunity to capitalise on our strengths and to connect with our counterparts across the world to support broader trade and investment of all types. And I'm incredibly proud of our legal services market here in the UK. It is one of the largest in the world, and over 200 foreign law firms call London their home. As one of the most open markets, it allows virtually unrestricted commercial access, something which will undoubtedly be crucial to realising the successful vision of a global Britain's contribution to a flourishing global market. Next month, I will be speaking at London International Disputes Week, which celebrates London as a leading global centre for dispute resolution, and I hope to see many of you there. The UK government and UK legal services community warmly welcome the range of reforms that have been introduced in Uzbekistan since 2016. The opening up of the Uzbek market and the commitment to the rule of law and a more favourable environment for business are particularly exciting changes. And I know that they will be welcomed by Uzbekistan's trading partners right across the world. The UK government is proud to have supported these reforms, and we welcome continued progress in this space. The UK will always stand for the rule of law and the independence of the judiciary and the legal professions because they act as safeguards of freedom and fairness in our democracy. As such, we will always welcome the work of like-minded nations in advancing these most fundamental principles. The UK already has a strong connection with the Uzbek legal market, and numerous UK firms work in partnership with local firms and lawyers, building the knowledge and the capacity to provide Uzbekistan business with the expertise and the confidence to compete and to thrive, both regionally and globally. I believe that this is the foundation upon which we can foster our trading relationship with Uzbekistan, particularly in the area of financial and professional services. Equally, Uzbek law firms looking to develop their international practice will find the UK market to be a very welcoming one, with a local pool of extraordinarily talented legal professionals. And what they'll also find is a legal system that is at the heart of global commerce. As forms of dispute resolution, such as international arbitration, grow and become a fundamental tool for trade, our English and Welsh common law system, with its reputation for fairness, effectiveness and transparency, continues to be the preferred choice for international business. Arbitration will, of course, be of huge importance to any country with an interest in foreign investment and global trade. And when the Tashkent International Arbitration Centre opened in 2019, it demonstrated Uzbekistan's ambition in this area of the law. And I know that the UK legal sector is hugely keen to support the growth and success of the centre. The Slim Foundation is already working with Uzbek colleagues on projects to build capacity for judges, demonstrating a desire to collaborate between our two jurisdictions. The City UK is also working with the Uzbekistan government on the creation of an international financial centre in Tashkent. This joint venture is about developing an IFC that is based on English common law and how best practice can be shared between both of our countries to improve conditions for business, strengthen the rule of law, and enable sustainable economic growth. Now, I think it's fair to say that the vision of law in the Fourth Industrial Revolution is not about any one thing. Law 4.0 has many facets: adaptability in harnessing new technology to deliver better services, openness in our markets, which removes obstacles to trade, as well as strong arbitration that builds confidence in the law, are no doubt among them. If there's one thing we know, it is that we cannot anticipate every development in the law. In a world of such rapid change, there will be no doubt surprises, and we will need to react. With that in mind, it's more crucial than ever that we collaborate in each area that I've mentioned, so that we can together work to realise our common goals. I hope the exciting programme of events to come during this forum will further that aim and be of huge benefit to everybody involved. Thank you for listening. It's a real pleasure to join you today, and I want to thank
Katta rahmat, Janob Lord.
Thank you very much, dear Lord Chancellor. And in fact, you have encouraged to cooperate with Great Britain, and actually we appreciate that. And now we would like to give the floor to Deputy Justice Minister Mr. Lee Kansi.
Lee Kang-sop, Minister of Government Legislation of the Republic of Korea. I'd like to express my sincere congratulations on the second International Legal Forum hosted by the Ministry of Justice of the Republic of Uzbekistan. I am pleased and honored to deliver a congratulatory message and thank Minister Ruslanbek Davletov and all those involved in preparing for this event for their efforts. Although we cannot meet face-to-face due to the COVID-19 pandemic, I'd like to express my gratitude to experts from around the world for sharing their insights and experiences on the vision of law in the era of the Fourth Industrial Revolution. Korea and Uzbekistan signed a declaration on strategic partnership in 2006. The bilateral relations were upgraded to a special strategic partnership in 2019, also vowing efforts to further expand our cooperation. In this process, the Ministry of Government Legislation of the Republic of Korea and the Ministry of Justice of the Republic of Uzbekistan signed a memorandum of understanding for legislative exchange and cooperation in 2009, and since then, for the past 12 years, we have continuously strengthened our cooperative ties in the field of legislation. In particular, in 2019, former Minister of Government Legislation Kim Wei-suk attended the first International Legal Forum held in beautiful Tashkent, known as Oasis of Central Asia, and gave a congratulatory speech. The theme of today's forum is Vision of Law in the Age of the Fourth Industrial Revolution. It is of great significance for legal experts from around the world to have in-depth discussions on the vision of law in the era of the Fourth Industrial Revolution, represented by hyper-connectivity, hyper-intelligence, and hyper-convergence. In 2017, the Presidential Committee on the Fourth Industrial Revolution was established in Korea to swiftly respond to exchange and facilitate innovation based on intelligent information technology such as data, network, and artificial intelligence. The Presidential Committee, where the private sector and the government work together, identifies regulations that hinder the growth of new industries through a regulatory improvement hackathon and improves various laws and systems to promote policies related to the Fourth Industrial Revolution without delay. Our ministry recently enacted and promulgated the General Administrative Law, unify the legal principles, and protect the rights and interests of the people. It is expected that the unified standards for systems stipulated in separate laws can be established, enabling rapid regulatory innovation and further strengthening the protection of the rights of the people by guaranteeing an opportunity for re-examination of administrative dispositions. In addition, the General Administrative Law allows us to prepare for future demand by forming a legal basis for taking an administrative action with an automated system or a system using artificial intelligence technology. Each country has achieved economic growth and social development based on laws and systems that provide a solid institutional framework. Laws and systems are the foundation for establishing national policies and designing new systems in response to changes. I believe countries around the world would be able to quickly adapt to rapid changes and come up with new alternatives by sharing their experience of making laws and relevant knowledge at today's forum to resolve common challenges. I would like to extend my appreciation again to Minister Ruslanbek Davletov and the officials of the Ministry of Justice for hosting this forum and inviting me to this event. I hope that cooperation between our two organizations will continue to develop further in the future. Lastly, I wish you a successful Today Forum. Rahmat.
Sizga ham katta rahmat, janob Siyok. Haqiqatda Koreya Respublikasi bilan O'zbekistonning hamkorligi juda ham strategik ahamiyatga ega.
Thank you very much. The cooperation between Korea and Japan are of strategic nature, and in general, through reforms we implement our new experiences, and it is very useful for us. And I think that during this forum we will have an opportunity to discuss all the things in detail. Another very respected guest of ours is the Ministry of Justice of Japan, Yuko Kamikawa. He will also provide deliver her speech.
An honor to deliver this message on this very special occasion. I would like to begin by expressing my heartfelt congratulations on the successful opening of this international forum, the second Tashkent Law Spring, organized by the Ministry of Justice of Uzbekistan. I also commend the organizers for their dedication to the successful holding of this forum. Digitalization and ICT innovation have brought significant changes to the systems of societies worldwide. In this light, it is extremely timely and meaningful to discuss the agenda, Law 4.0, the vision of law in the age of the Fourth Industrial Revolution. For its part, the Ministry of Justice of Japan is accelerating its effort to further enhance digitalization and the use of information technology in the field of justice and law enforcement. By doing so, we believe that convenience, efficiency, and quality of services would be improved, and that it would take us a step forward in our effort to achieve access to justice for all. To list some examples, with respect to administrative procedures on justice affairs in Japan, currently over 40 procedures make available online-based applications. We are also vigorously working towards incorporating IT as essential means in the conduct of civil and criminal court proceedings. As you may recall, last month, the 14th UN Crime Congress was held in Kyoto, Japan. The Kyoto Congress was held in a hybrid format, which is becoming a modality commonly applied, enabling in-person and online participation. It allowed for broad participation from around the world. There were more than 5,600 registrants from 152 countries. The successful holding of the Kyoto Congress has demonstrated how such an event could be held by making use of advanced technologies, despite the difficulties posed by the COVID-19 pandemic. The experience we gained through the novel approach taken in relation to the Congress has indeed been rewarding. The enhanced use of information technology and the globalization of information networks enrich our lives and societies. They are broadly acknowledged to be the driving force of development and to have clear advantages. We must, however, be mindful of the negative impact they bring at that same time. It is true that the change of working styles, such as increased remote working, contribute to better balance the time we spend for our work and life at home. It is also true that nowadays we are more exposed to information security risks. Furthermore, it cannot be overstated that children and youth, who are the future of our societies, are especially vulnerable to the side effects of digitalization. Unlawful activities in cyberspace, such as cyberbullying, cyber harassment, and cyber stalking, pose serious risks to their mental health and well-being. I must highlight that one of the key achievements of the Kyoto Congress Youth Forum was a specific reference to those concerns, and the pressing need for them to be addressed was made in their recommendation put together by the youth representatives. The international community is faced with various challenges, including divide in terms of social systems, culture, and financial resources. These challenges have only become more complex with the pandemic. Especially in these difficult times, we must continue to ask ourselves the question, is technology a friend or foe? There is obviously no simple or straightforward answer to this question. As such, in my capacity as a Justice Minister, I strongly feel it being my responsibility to take measures, such as amending rules and regulations to meet the actual needs on the ground with a view to achieving a sustainable society. In performing my duties, it is vitally important to understand the global situation, both positive and negative, regarding the enhanced use of ICT. No society can tackle these challenges alone. International cooperation is key to achieving a sustainable society where one will be left behind. Finally, I would like to extend my best wishes for all the success in this forum. I am convinced that this forum will serve as a great opportunity to exchange good practices, views, and perspectives. I very much look forward to the discussions and the collaborating with you. Thank you very much.
Muhtarama Kamikawa xonim, sizga haqiqatda
Esteemed Yuko Kamikawa, Madam, thank you so very much for your time devoted to us. Thank you so very much. My dear participants, using this great opportunity, I would like to express my deepest gratitude to all the participants, to all the plenary session speakers for sharing your opinion, for all the warm words, and I'd like to wish you great success as well. Well, right now I would like to cover a couple of words with regard to the agenda of our forum. So we have 15 discussion sessions, roundtables, so-called site meetings. So we will have great discussions, and there will be matters discussed in the area of mediation, in the area of intellectual or artificial intellect, and we will be talking about ICT and recent trends in the area of jurisprudence. So, number of roundtables will be covered within these 2 days, and I truly hope that there will be a great opportunity to have open discussion amongst us. Besides, we know also that they will be all broadcasted online. During breaks, I would like to also say that there will be a coffee organized for all the participants, and we are also providing you with lunch. We hope you will share it with us. Thank you very much.
Adliya vazirligiga ishga kirmoqchi edim.
Adliya vazirligida quyidagi boshqarmalar bor. Xohlaganingizni tanlashingiz mumkin.
yordamchingiz bor. Advice.uz fuqarolarga hamisha hamma joyda istalgan muammo yuzasidan konfidensial bepul huquqiy maslahat beradi. Shu yil jamiyatda huquqiy ong va huquqiy madaniyatni yuksaltirish tizimini tubdan takomillashtirish to'g'risidagi prezident farmoni imzolandi.
Huquqiy bilimlarni, qonunlarni, mazmun mohiyatini, ta'lim maskanlari, ommaviy axborot vositalari, internet resurslari, adabiyot, san'at, diniy muassasalar imkoniyatlaridan foydalangan holda samarali usullar bilan targ'ib qilishimiz zarur.
Ushbu vazifaning ijrosini ta'minlash maqsadida Buyuk Britaniyaning O'zbekistondagi elchixonasi bilan hamkorlikda Advice.uz loyihasi amalga oshirildi. Citizens Advice butun Buyuk Britaniya bo'ylab faoliyat yuritadigan 316 ta mustaqil xayriya tashkilotlaridan iborat tarmoq bo'lib, u fuqarolarga bepul huquqiy maslahat beradi. Tarmoq 1939-yilda tashkil etilgan bo'lib, hozirda unda 7000 nafar xodim va 22000 dan ortiq ko'ngilli volontyorlar faoliyat yuritadi. Advice.uz loyihasini yaratish bo'yicha mutaxassislar 6 oy davomida ishlashdi. Buning uchun ishchi guruh tuzildi. Ishchi guruh a'zolari Citizens Advice byurosi bilan tanishish va faoliyatini o'rganish maqsadida Buyuk Britaniyada bo'lib qaytdilar. Safar davomida o'zbekistonlik yuristlar uchun Citizens Advice mutaxassislari tomonidan prezentatsiyalar, treninglar uyushtirildi, uchrashuvlar tashkil etildi. Yuristlar jamoasi tomonidan 1000 dan ortiq kontentlar yaratildi. Ushbu kontentlar mazmuni aniq va maqsadli, tili sodda va tushunarli, saytga joylashuvi foydalanuvchilarga qulay bo'lishi uchun huquqshunoslar, filologlar, dasturchilar va boshqa qator mutaxassislarning xizmati katta bo'ldi. Mehnat munosabatlari, sog'liqni saqlash, bank sohasi, ijtimoiy himoya, sud huquq masalalari, soliqlar kabi 20 ga yaqin yo'nalishlarda ma'lumotlar berilgan. Ma'lumotlar imkon qadar
And digitalization also is in place in such a conservative area as international treaties. So this January convention on international agreements, the Singapore Convention, became effective for the Republic of Belarus, and that convention is aimed at peaceful resolution of disputes, and it makes it possible to implement the international mediation agreements reached also by electronic communications. And annually, we aim to develop consistently any area within our competence. And sometimes this is necessitated by social requests, law enforcement practices, and new opportunities to improve our activities. Dear colleagues, thank you so very much for your attention. Hopefully, so the experience of Belarus in some areas will be useful for you as well. Thank you so very much, Oleg Andreevich, for your interesting message. And it is important to know that the Republic of Belarus demonstrates very good results in the area of digital technology. Thanks to the state program for digitalization, Belarus is on the top 40 countries list in the area of digital government development. In this area, regularly we cooperate with the Ministry of Justice of the Republic of Belarus, and another long-standing partner of the Ministry of Justice of the Republic of Uzbekistan is the Ministry of Justice of the Republic of Kazakhstan. Mutually beneficial cooperation between our countries is actively in all areas, especially in trade, economic, and investment sectors. The forum participants are not only the legal professionals, but also representatives of the business sector, and that's why I guess a presentation by Ms. Akhmetova will be of interest to all of them. The floor is yours. Good afternoon, dear Mr. Davletov, dear colleagues. Allow me to express my gratitude for organization of the platform for the international legal community that enables us to discuss the issues pertaining to development of the present-day law. In my message, I would like to brief you on the ongoing policy in the Republic of Kazakhstan to ensure a conducive investment environment. It is well known that attracting investment in the country's economy is one of the drivers for the country's development overall, and since independence, Kazakhstan has been taking every measure aimed to shape the legal foundation for a conducive and attractive investment climate. So, in 2015, the investment legislation was codified. The business code was adopted, and currently this is one of the main legal documents regulating issues related to raising and protecting foreign investment. While discussing the content of this document, we have to highlight that the provisions of the business code offer an investor full-fledged and comprehensive protection of rights and interests, and it envisages a number of privileges and preferences. For example, the state guarantees stable implementation of the contract provisions for the contract signed with Kazakhstan authorities, and it means that the contract will not change even if the law and the legislation change. So then remedial actions in case any harm is caused by public officials. And also we have to highlight there are preferences related to waiver of the VAT when grants are provided, and also the right to get the compensation for up to 20% of the cost of construction works, procurement of equipment, and quite a few other preferences. And also the business code introduced the procedures for operations of an investment ombudsman, and the primary objectives of that ombudsman is to protect the rights and legal interests of investors and to submit proposals to the government to improve the investment legislation. we have to highlight the challenges faced by investors are always tracked by the country's leadership. And in this context, we have to mention that back in 1998, the Council of Foreign Investors under the President of the Republic of Kazakhstan was set up. And its primary objectives include development of recommendations and proposals to identify the main areas for investment policy of the country and to improve the investment climate. In addition, to make it more convenient for foreign investors, Kazakhstan introduced the principle of one-stop shop. That's the new mechanism to ensure interaction among government authorities and investors, which minimizes their participation in document preparation and facilitates as much as possible interaction with government authorities. So investment legislation also includes the constitutional law on International Finance Center in Astana. I guess you are aware that in Kazakhstan, we have the leading financial services center with the special legal regimen. And the center's objectives include facilitation of operations and protection of rights of investors. And for that, in the area of international financial center, so the cases and norms of Wales and England are in use. And the center provides unprecedented settings for operations which are unparalleled in the former Soviet space. And we have streamlined visa regimens and labor arrangements, and the activities of the financial center started officially on the 1st of January 2017. And in 2018, under that center, we have the court, which includes the leading legal professionals in Europe. So that court is independent. It relies on the principles of common law of England and Wales. And the court also processes disputes under the commercial and civil law, including investment-related disputes. And currently, the court has reviewed some 96 cases. Most of them were regulated using mediation.
Передовой опыт развитых зарубежных стран в Казахстане.
We would also like to emphasize that in lawmaking process, we also adopt the experience of other countries. Based on the experience of Great Britain, we were able to revisit the whole process of developing national legislation and force, where while developing draft laws, we have a preliminary development of so-called green and white books. Right now, before the draft laws are being created and their concepts are being drafted, we have to perform consultation work with targeted expert groups, and that's the Green Book. And then supported initiatives will be introduced to the draft law, and that's the White Book. So all these measures are there in order to facilitate more open dialogue with all stakeholding entities, which is very much needed to take into account all the opinions of all the players of business environment. So at the level of establishing newly developed regulations and requirements, we're able to resolve most relevant matters, including the matters of investment area. In general, as for developing proper and friendly business climate, we have to identify the efforts of Kazakhstan to provide for the project doing business under the World Bank in order to make it easier to perform business. So a lot of reforms are ongoing, and right now we are having just notification procedure in place. We've reduced administrative and other barriers for local domestic investors and for foreign investors. The work in this regard is very vibrant, taking into account the to be in compliance with the requirements of business society and also with the recommendations of OECD countries. Besides, I would like to emphasize that the matter of attracting investments is under current control of the government. The President for the year 2021 have defined 7 main areas of development we foresee raising self-establishment of the economy, development of entrepreneurship, quality, digitalization, improval of infrastructure to improve the welfare among the population, and also to properly develop human capital. I think that these measures will facilitate to reveal investment capacity of our country. My dear colleagues, this is just a very small snapshot of the work which is going on in our country to improve our investment climate, which I was able to share with you within this short period of time. Once again, I'd like to thank for giving me the floor. I wish you great success and fruitful work of this forum. And I would like to invite investors from the countries of Central Asia and from those countries that participate in this forum to invest in Kazakhstan. Thank you. Thank you very much for your comprehensive presentation. It is my great pleasure and interest to listen to your report, especially when you are covering development and adoption of the entrepreneurship code in the Republic of Kazakhstan. So there was this decision made by our president to develop and then to adopt the code for entrepreneurship in the Republic of Uzbekistan. So your experience is of a great importance for us. Thank you. Our next speaker is Minister of Justice of the Republic of Azerbaijan, Mr. Mamarov. Thank you very much, esteemed colleagues, ladies and gentlemen. First of all, I'd like to thank our Uzbek friends, headed by esteemed Minister Mr. Davletov, for having this second Tashkent Law Spring forum, legal forum, which is covering very important topics, even during this pandemic. This is a very important initiative because it's a great opportunity not only to share experience and best practices, but also it is a great platform for bilateral development of our relations. So we came down to a conclusion to sign a final document to collaborate with the Ministry of Justice of the Republic of Uzbekistan. Technology is a strong engine and it moves forward. So of course the ICT is one of the priorities for all of us. This area is accelerated in its development. So coverage by internet based on the World Bank report, we know that our country, for several years, we are as part of reforming countries. So, and as for the economic forum, Azerbaijan upholds the place number 5 in adhering of the government to the commitments in the area of reformation. So we have number of reforms to perform number of changes and transformation in our country. I'd like to emphasize in particular that development of digital society is one of 5 priorities for the national and social and economic development program of Azerbaijan for 2030. Under this context, I would like to cover several matters. So we have established a regional center for Davos World Economic Forum. So we have several centers of this nature, and then we of course try to cover the fourth industrial revolution, which covers all the areas of our life. As General Secretary Antonio Guterres has mentioned, the rule of law in future should be developed based on technology and with the help of technology in order to allow access of all the people to justice. Legal reform to be successful, so it should be based on systemic and gradual, properly developed policy. So the most important priority for us is to strengthen the constitutional law, to protect human rights, to provide for equality. So the role in this process is quite important, taking into account that legislative platform is the good ground for the policy in the Republic of Azerbaijan, and vibrant processes are ongoing. Within 5 years only, we were able to adopt 4,200 laws and decrees of the president, and practically each of them has been developed together with the great participation of Ministry for Justice. Besides, we were able to establish permanently renewed, free of charge, internet platform for legislation of the Republic of Azerbaijan, the number of users of which is increasing, and it's now somewhat about 1/4 of the 10 million population of the Republic. Implementation of the policy is there for justice as well, and one of the most important areas is judicial approval. The implementation of ICT there is increasing efficiency of the justice system in general and judicially in particular. So blockchain technology is being implemented, and we do know that there are some cases which are resolved without even participation of any judge. So modernization of judicial activity is improved. So in order to even more improving it, we have decided to establish a completely new platform. So in that regard, a lot of support has been provided by World Bank. So it was successful collaboration for more than 15 years, and we are implementing joint projects. We were able to develop an information system, electronic court, using the novelties of the whole world. So it covers the whole process from the moment of putting the complaint down to the court hearing. So audio and video records are provided, and also video conferencing feature is there. So 10 times we've reduced the time for trials. So for that purpose, we were able to establish a unified portal of judiciary and personal electronic office for judges. So we are now almost paper-free judiciary. So it expanded the access to courts and reduced the red tapping, provided for accountability and transparency, which is very much important to resolve the matters of civil justice. Quite soon, we truly hope to cover the whole judicial system applying this platform. We are very much keen on transparency, so electronic publication of all judicial decisions with the high level of confidentiality. We apply the specialized software to properly cover the confidential matters. Mobile court provides for the free access to justice, to obtain information as soon as possible, to be part of the process online or remotely. World Bank has admitted that our work is very successful, and in the report Doing Business 2020, it has been covered. Judicial management is very much important. The system that we've developed allows us, based on the judicial statistics, to develop different types of analytical reports to assess the work of courts and judges, to identify how productive they are. This system has been identified by the European Council, so it is the whole revolution in judicial management. So we were awarded by a very popular award. So artificial intellect, well, everyone is referring to that. Quite successfully, we're applying automated system of resolving cases within the area. So the suit, well, we may sue right now, and we may put a complaint electronically, so it is resolved within 24 hours. So 10,000 judicial decisions of that level has been produced based on artificial intellect. Some categories of judicial decisions are being generalized. So final decisions are also planned to be produced this way. So this single electronic base for judicial decisions is being established. Well, taking into account the pandemic problems and challenges, the law has been adopted for virtual court hearings, another trend. Not only here, but in many other jurisdictions, is the humanization of criminal policy. In Azerbaijan, based on the initiative of our leader, global reform has been launched in this area, which is continued until now. As a result, we were able to introduce 500 amendments to the criminal law, including decriminalization of number of offenses and crimes. Number of alternative punishments has been introduced, so that's why every seventh convicted person has been released. The alternative system allows us to improve the service of probation. Within a short period of time, we're able to apply these electronic bracelets to watch online the convicts, to perform electronic monitoring. During pandemic, the matters of digitalization were quite paramount. So probation and also conditional release has been implemented widely. So civil society supported us on that. So quite rapidly, and there is a quite expedient process in reviewing these matters. Switching the PPP, the public-private partnership, up to the very strong higher level is now ongoing. Assam Service is well aware to many of our colleagues that has been established already because that system has become quite an exported brand of our country. By application of this program, somewhat about 40 entities do provide for more than 300 public services. So that's why everyday or petty corruption has been almost completely eradicated. More than 40 million people of our people were able to utilize and consume the services. We're so happy that legal services are very much important for our people. 45% of all documents that has been issued all over are issued by the Ministry of Justice. So public service is very much important, and the experience of our public service is there for the scaling up. So we became flagship of applying the ITC to support the e-government, and 450 electronic public services are now provided. So in 2019, in UN Forum, we have been also awarded for development of public services using digital area. Another thing, so we also are quite an important part, being a Ministry for Justice as part of the government. So last year, the number of consumers raised up to 1.5 million. For several years, when we talk about registration of the different statuses for our nationals is also increased and of great interest amongst our international friends. I'd like to emphasize 24/7 notary services online is now being provided using so-called electronic offices. That's another step to digitalize notary services. So there is notary booth right now is being established in banks and also in many other services where needed. Along with that, we also developed notary portfolio, which allows to perform any types of notary services, to print out and then to release and issue any documents, you name it. Besides, we've developed also a mobile application. The name of it is Notariat, so notary service. You may download it to your cell phone, and all the information with regard to notary services is there. With the help of this application, without visiting notary service, notary office, just using video call to the notary officer, they may perform number of notary actions. My dear participants, dear colleagues, for Azerbaijan, last year was very difficult, very complicated, not only because of pandemic, but also due to the military actions with Armenia, and I've told about it. For 30 years, 20% of territory of Azerbaijan has been occupied by Armenia. For so many years, they were ignoring resolution of UN, which was telling them to remove themselves from this land.
So peaceful negotiations failed under the aegis of Minsk Group of OSCE, but their aggressive actions brought to escalation of the conflict and start of military actions. Armenia could not stand up against the patriotism of our people, so they were defeated in the battlefield. Even though violating the humanitarian law, they were unable to win. So, but there are so many peaceful people, ordinary people suffered as a result of one battle. Number of people died and so many wounded. Imagine a very small city cafe has been covered by 16,000 bombs. That was blanket bombing. And then there is another small town which international mass media called Azerbaijani Hiroshima. So covering themselves as the humanitarian aid, they provided weapons to the battle areas. Fortunately enough, Azerbaijan was able to release the occupied territories. Within several years, they has been used for illegal commercial activity. We had to send more than 50 requests for legal assistance all over the world within the framework of investigating these crimes, also into the countries participating to this forum. I'm hopeful that they will be reviewed properly. Now we have to do a lot to do demining of released lands, because the aggressor has demolished everything. So they've left behind themselves just burned land. They were able to completely remove and destroy religious values of our country, and all international society see it. Even during Second World War, religious memorials were not demolished. After the war, Armenia is not providing us with the minefield map, which jeopardizes the life of peacemakers and civilians. Now the number of those wounded and killed is increasing. But still, Azerbaijan will put all the efforts to develop regional collaboration at a novel format. We truly want to restore the life in this territory, applying smart cities concept. And we will invite also international experts. Taking into account this current concept is also applying ICT in that regard to improve efficiency, to also provide for better quality of public services. The Ministry for Justice are well involved in this process. My dear friends and colleagues, today we hear a lot of very interesting best practices examples from different countries and we are happy to get enriched with all these ideas. And we truly hope that this will bring to a completely new level of our relations and will improve our collaboration and will produce ideas for new reforms. Thank you for your kind attention. Esteemed Mr. Minister, thank you very much for your very interesting presentation. It is our pleasure to emphasize that just recently, a delegation of the Republic of Uzbekistan, the Agency of Public Services, has visited Azerbaijan, and thank you very much for your warm welcome and for all your efforts to share your great experience in providing public services to the customers. I'd like to emphasize that we also have strong relations with Singapore, and we will sign a memorandum of understanding between our ministry and the Ministry of Singapore. That shows the mutual interest towards collaboration and exchanging experience. Singapore experience is very much interesting for us from the point of view of providing for transparency and openness of lawmaking process, high level of digitalization, development of arbitration and mediation institutions. So I'd like to pass the floor to our esteemed speaker, Mr. Shanmugan. Please, the floor is yours.
Thank you. Your Excellencies, I made some short set of remarks earlier, and thank you for the opportunity for me to participate again after the earlier session. During this session, I will touch on sovereignty, new media, and the rule of law. Over the last few years, we have seen a very important development, which is loss of trust in institutions across the world. And this loss of trust affects both public institutions and private institutions. Loss of trust in governments, political systems, media, financial institutions, businesses, professions, other institutions. If we take a step back, we'll see institutions are the building blocks of societies. They deliver economic benefits, they deliver societal benefits. Institutions in any country play a crucial stabilizing role to manage diversity and hold communities together. Institutions succeed, and when I say institutions, whether it's a parliament, whether it's a cabinet, whether it's a police, whether it's the army, they in turn depend on trust and legitimacy in order to persuade the public to make sacrifices for the common good. You need their trust and legitimacy to encourage societies to come together to solve problems, to implement policies, to take actions for society's benefit, and to steer countries through crises. But when people in a country lose trust in institutions, then that creates a vicious cycle. The institutions lose their ability to make change. Today in the world, we see several factors contributing to this loss of trust. One is, of course, the increase in inequality in many parts of the world. Two, political systems are finding it more difficult to deliver what people want. Three, there are changes in the way traditional media in many countries deliver news. And four, the effect of new media. And for my purposes today, I'll just focus on the effect of new media. New media is an information superhighway. It has got many byways. It links to different groups in society. It has greatly enhanced the sharing of knowledge and information and connectivity. It has created tremendous productivity. It has made lives better across the globe. But it has also now been used to send out on an industrial scale falsehoods to mislead people. There are several forces driving this, including the digital advertising models, which have turned websites into basically real estate, and abuse of new media by people seeking to spread hate, terror, and to create loss of trust in institutions and governments. And modern technology has made the creation and dissemination of falsehoods easier, cheaper, more profitable. And it's happening in many countries of the world. In fact, almost every country, I would dare say, unless you don't have an internet. And often these falsehoods, what they do is they affect what I would call the infrastructure of fact, upon which the proper functioning of society depends. And if we don't address this, there is going to be deep damage to institutions across every society, including those which uphold the law, like the police and the judiciary. Many examples all around the world, Europe, Asia, of fabricated stories, the US, of police brutality about immigrants, spreading xenophobia. Every which way you will find this. Now, countries have tried to deal with this through domestic solutions, legislation. But really, the borderless nature of new media means when countries try and deal with this issue individually within borders, the effectiveness is limited. It's important for countries to coordinate, work together across jurisdictions, and we have to consider some serious questions. How can we get a more united response across the globe? Does international law have to come in? What kind of changes do we need to make to our own legal systems to make sure that we are prepared to deal with this industrialized age of falsehoods? These are difficult issues, no easy answers, but it goes to sovereignty itself, because countries' ability to decide for themselves and in the interest of their people is now being undermined by people who live outside and who can easily undermine institutions and their legitimacy. So forums like this are useful for countries to learn from each other, exchange best practices, share ideas, and I look forward to the discussion later. Thank you very much.
Огромное спасибо.
Thank you so very much, sir, for your comprehensive presentation, and I would like to encourage to promote the discussions during our session, because I guess maybe there will be no such opportunities later on when you will have 6 ministers of justice in the same room. So if you have any additional questions, we are willing to hear from you, to give you answers. And with your permission, we would like also to hear from our national experts. Rahmatjanaka, please. Good afternoon, dear moderator. I would like to extend my gratitude to all the speakers for such comprehensive presentations. And today, definitely, effective public administration is not possible without implementation of digital technology. That goes without saying. And of course, to effectively introduce digital technology, it's a must to have good education and, of course, scientific support. In this context, I would like to draw attention of our colleagues, participants in our today's session, to the issues pertaining to digitalization of legal education and scientific support to the whole process, digitalization of law. And as a rector of Tashkent University of Law, using the example of our university, I would like to inform you on the digitalization processes, especially I want to highlight acceleration of these processes when the pandemic started last year, so starting last March. All universities in Uzbekistan switched to distance education. And of course, we have to resolve a pressing issue. Over a short period of time, we have to fully digitalize the content and to launch a relevant educational platform. And within 1 month, our universities made it happen. In Tashkent State University of Law, using the Moodle platform, so we offer the online distance education platform, and currently this platform gradually, step by step, is becoming richer, and all types of educational content are included. So some 30,000 various modules have been uploaded to that portal, and step by step, the quarantine restrictions are being lifted in our country. And at the same time, we can imagine that without digitalization and online technology, it's not possible to ensure quality education. And elsewhere, we are using digital technology in education. And also, starting the next academic year, we are launching the new project, Electronic University, which envisages complete digitalization of all university areas, all educational processes, grades, rankings, and all documents will be submitted electronically. In addition, another important objective is that we fully revised curriculum and training programs. And we have introduced new modules to train legal professionals, which are essential, such modules as legal information technology, cyber security, cyber law, and quite a few other modules and areas which are of great importance to train future lawyers who, after graduation, tomorrow will be able to work using digital technology. And the second important area which I want to highlight is scientific support to the processes of digitalization of the law, and they are also very relevant. In this context, in our university, we are also developing the science in this area. So we have 12 specialized councils for defending theses, and as part of defending theses, we pay special attention to development of the digital law. Also, last year at our university, we opened the new unit, Legal Tech Laboratory, and this is developed now worldwide, and the legal lab of Tashkent State University of Law unites our researchers, students who express their interest in digitalization of the law. And also we got some products, namely the online platform to sign smart contracts with students. And we have launched the application to automate and to ensure online implementation, online selection of the topics for master's and bachelor's papers and for PhD papers, and the Legal Tech Lab has yielded its first results. And overall, I believe in our today's forum, we've got a very good platform to discuss digitalization of law. At the same time, later on, it will remain such a platform to develop legal education and science further, namely in digitalization of the law. And summing up, taking advantage of this opportunity, I would like to address our ministers of justice and invite them to the 30th anniversary of Tashkent State University of Law. So this year we will celebrate that anniversary, and in the fall we plan a large-scale forum of students, and we will be happy to see representatives of departmental universities and ministers of justice and representatives of other universities of their country at that forum. Thank you very much, Mr. Hakimov, for your informative message. Yeah. So if anyone has any questions, please go ahead. But please introduce yourself and use the mic, please. If possible, microphone, please. I apologize. If possible, please speak up. Good. Okay. I'd like to welcome all distinguished participants of our today's forum, and taking advantage of this opportunity, I would like to ask a quick question. So I represent the Ministry of Transport of the Republic of Uzbekistan. I'm a lawyer. My name is Anvar, and So with regards to protection of the legal foundation of the state and clear understanding of legal documents ensures protection of rights and implementation of its functions, and official interpretation of provisions of laws and constitution of the Republic of Uzbekistan is provided by the Constitutional Court of the Republic of Uzbekistan. An official interpretation of bylaws is provided by the agencies that adopted them. Do you think changes are necessary? Namely, that official interpretation of legal documents should be done jointly with participation of the adopting agency and representatives of the Ministry of Justice. Thank you. It's a question to whom? I think to colleagues of the Ministry of Justice. Let me answer. Yes, please, Mr. Davletov. Thank you very much for your question. So first of all, we need to pay attention to the provision in the law saying that official interpretation is not the activity that is done daily. Official interpretation is provided only if there are contradicting practices or uncertainty or lack of clarity, because many people get confused that if you need an interpretation, they approach government agencies requesting an official interpretation. And that's why here we need to differentiate between these aspects, when it is really official interpretation or when it is providing explanations. And as the Ministry of Justice, based on our mandate, we provide the statements on behalf of the Ministry of Justice with regards to any given document. So we provide explanations for legal and regulatory documents. So we state our position and like the official interpretation. And there are very few cases when official interpretation is provided. And one more specific point is that official interpretation of a document, it's the same document that is considered to be the main document. So if it's the resolution of the Ministry of Justice, so the official interpretation also should be provided in the format of the resolution of the Cabinet of Ministers, in case it's the resolution of the Cabinet of Ministers. And it's a very challenging process. Moreover, the Cabinet of Ministers is the body composed of many members, and they have special procedures to reach a decision. And so as legal professionals, so we also state and defend our position when providing legal explanations and interpretations. But in general, we have to take a look at that issue because we don't have any provisions, procedures, and the methodological basis to provide official interpretation. For example, what methods should be used, like who should do that, what the procedure is, in what timeline it should be done, and in what aspects it is considered that we have that need for the official interpretation. So when we can definitely say that there are contradictory practices in law enforcement, and when there is lack of clarity, and why we have this lack of clarity, where it comes from, and definitely that area should be more detailed, and there should be detailed procedures. And if you remember, there was the draft provisions, and now we try to promote these provisions to make it clear for everyone, so we could have legal certainty pertaining to these relations. Thank you. Thank you so very much for your informative response.
Пожалуйста.
First of all, let me introduce myself, Ms. Muzaffar Shakirov, and I would like to ask a question to the Minister of Singapore. My question is regarding the fight against the corruption. And as we all know, last year, Republic of Uzbekistan have established the anti-corruption agency in order to struggle against corruption. And as we all know, that the Singapore is one of the most leading countries all over the world with the lowest rate of the corruption. And that's why, can you tell us, please, what experience of Singapore can we take as an example and will be most, let's say, relevant to our country in such an important question? And what types of measures is Singapore taking to maintain such a good level of, low level of corruption? Thank you.
Спасибо.
Thank you.
Спасибо.
For law has stepped up for a short time to take a. I've noted the question, and we will convey that to the minister when he comes back, and he will answer the question later in this session.
Okay, thank you.
Пожалуйста, еще вопрос.
Please, any more questions? Gulnoza?
Спасибо.
Thank you, esteemed moderator, dear colleagues. I'd like to thank the organizers of this forum for extending invitation and for giving opportunity to speak today. And going back to returning to the topic of our forum, I'd like to comment on some of the matters. In 2019, when for the first time this forum has happened, Tashkent Law Spring, no one could even imagine that the topic, digitalization topic and digital transformation topic or digital transformation will become so trendy and so very much important matter for the world development within such a short period of time. Artificial intellect, robotic techniques, internet, 3D printing, internet things, and bio-neurotechnology, all these novelties up to date has become the part of our life. There are no doubts. There is no doubts that the pandemic has demonstrated that the global society was not ready to be able to respond to such a challenge. And that gave a great impetus, great push towards further development of ITC, both at the micro and macro level. So digitalization impacts international relations right now, international economy, international law, and also supports newly developed formats for international collaboration. On one hand, we start to have new concepts, new phenomena, and even areas of the law which have to rapidly revisit the whole mechanism and algorithm of and legal system in total. Digital transformation is impossible without fundamental modernization of modern legal platform and symbiosis of legal massive or bulk parts of development. So we have to discuss international law and developing it under conditions of cyber reality and digital transformation that will also bring to revisiting, rethinking the whole theory of modern law, international law, taking into account vibrantly changing trends. Of course, the platform of legislative acts is there. A number of basic international agreements, laws are still there to provide for digitalization of the whole society and further development of information technology. At the same time, we would like to emphasize and then ask ourselves, with regard to the nature of development or establishment of those digitalized legal bulks of information, no matter what digital reality we have, at the level of developmental degree, it should meet the requirements of international law. We have 4 components in further development, and it's applied all over. It is digital diplomacy, big data, large data, and global management of internet, and electoral technologies, digital electoral technologies. So these components do impact tremendously to the world political reality and further development of all international relations. Digital diplomacy, it is actually the use of social networks to impact, to influence international audience, let's say, which is one of the strongest tools. Global management and governance within internet, that's the comprehensive approach. That's negotiations,
getting into agreement among stakeholding entities in the area of legal regulations within digital area, and that covers all area of our lives, innovative and quite actively developing areas for international relations, and foresees comparative analysis using electronic and digital voting in different countries, but also covers the problem of comprehensive impact of the state towards political situation. Development of informative and information technologies covers also human rights. A lot of experts has mentioned that we have new generation of human rights, digital human rights. Digitalization is not only foresees the whole new dimension. Those are not only the human rights, digital human rights, but newly developed mechanisms to protect those, like, for example, the electronic court trial, and many speakers has referred to that. On one hand, digital technologies do become reasons of developing new threats and problems and challenges. On the other hand, they reveal new opportunities. They facilitate newly developed international legal concepts and also establishment of new legal mechanisms. It's not only there to revisit and to refresh our knowledge in this area, but also we add new definitions, new standards, and new terminology. So digitalization impacts tremendously to development and complete reformation of legal profession, but also it threatens human rights. So we see structural gaps of modern set of life. So the processes of digitalization support development of new definitions and new strategic areas of international law. It provides for platform to promote new international initiatives, reveals new opportunities to expand international cooperation, and also supports the necessity of revisiting the whole theory of law. I would like to support our speaker, my previous speaker, and I'd like to support the previous speaker who was the principal of the law university. So I'd like to say that cyber reality and those challenges that we have to truly train and educate experts in this area. We have to educate them with this knowledge and for them to be able to respond properly. Well, thank you so very much for your comprehensive opinion. Please, any more questions? Questions or comments? Yes, please. Could you introduce yourself?
Singapore. I'm happy to answer if...
Yeah, Mr. Shangman, it was me. Can I just repeat my question? My name is Muzaffar Shakirov. My question was regarding the corruption, fighting corruption.
Yes, I'm aware of the question. I can give you the answer.
Yeah, thank you.
I mean, I'll try and answer as best as I can. You know, you got to first start with the acceptance that Singapore is a very small place. So what works here may not necessarily work in a much larger place. That's a starting point. It's a small city-state. But subject to that, it's a combination of tough laws and policies. So laws, we have probably among the strictest laws anywhere in the world in terms of corruption. The giving of any kind of benefit and the receipt of any kind of benefit is treated as corruption, not just in the public sector, but also in the private sector. So even if it's a company and you're a senior official in the company and you receive some money, or you receive a benefit in kind, you could be in trouble. You know, but many countries have very tough laws, but it's only as good as the enforcement. So we are very strict on enforcement. Our founding Prime Minister, Mr. Lee Kuan Yew, put the Corruption Eradication Bureau under the Prime Minister's office. So it's not under any minister. It's dealt with directly by the Prime Minister. And his emphasis is anyone, whoever it is, including ministers, can be the subject of investigations, and there can be no interference. It goes direct to the Prime Minister. And however small or big it's dealt with, I'll give you a couple of examples. Two officers, health inspection officers, walk around food courts. Food courts are places where they sell food, and their job is to look at and make sure that the place, hygiene standards are okay. And there will be about 50, 60 stalls. It was lunchtime, and one of the food courts offered some meal, which might be US $2 or $3, which they had. They were charged, and they lost their jobs, they lost their pensions, they lost everything, and they went to jail. On the other hand, we had one of our most senior ministers, maybe about 20 years ago, a very important man in the inner cabinet. There was a corruption allegation. He was being investigated. He wanted to see the Prime Minister, and the Prime Minister said, no, I'm not going to see you. Let the corruption investigation carry on. Let the court decide, and then we will see whether I will see you. The minister committed suicide. So whether it is small or big, everyone understands, whether it's private sector or public sector, if there is any hint of corruption, there will be an investigation. And right from the top, the rules are clear, and there is zero tolerance. At the same time, it also depends on our habits. So we, as a government, as public officials, we try and have habits which are very, very clear and careful. For example, every week we meet in order to have lunch, and we talk about policies. But because it's lunch and we are meeting to talk informally, the government doesn't pay for the lunch. We pay ourselves. We pay every month, and the money is shared to buy the food, and we have it. We drive into our ministry to park our cars, we pay. And everybody, all the senior civil servants who park in the building pay. So it's a different system. It's not easy to implement everywhere else. At the same time, we recognize that public servants and public officials and ministers cannot do the work. Many will not come forward to do the work if they are not paid properly. The official remuneration must be comparable. It cannot be directly comparable to the private sector, but we must have some reference point to the private sector, and people must be well paid if you want good people. So we have probably the highest public sector salaries in the world, whether it's ministers or whether it's public servants. You get highly paid in Singapore. We try and choose the best people to come into public service as civil servants, and they are paid very, very well. Yeah. They will still do better outside in the private sector, but in the public sector, they paid very well. And I can go on, but contracts, how they are structured, transparency, tender systems, all of them on the internet. Public can check, public are informed. The contracts that are coming up are all out there, so people can reference for themselves. So that's a sort of a short answer to a very complex issue.
Thank you so much for your comprehensive answer.
Thank you very much for your comprehensive response. Well, our forum is going on online as well. So if you allow me, I will read out some questions. Good afternoon. I represent CCNet company, Shahzod Azamov. The question is to Mr. Davletov. So you've mentioned that you are working on adopting the code for entrepreneurship. When exactly it will be adopted, and could you tell us about it actually? Development of this code foreseen by the state program, which has been adopted by the president, approved by him. So the project is ongoing with different ministries and agencies stakeholding in this matter, and I may just talk about the structure of this code. First of all, it will be fully the full systematization, I'm sorry, of all legislation enforced, which is covering entrepreneurship laws, sub-legal acts, bylaws, regulations, you name it. We'll try to do our best to have a comprehensive legal document which will absorb all other laws with regard to business area. So it will be the code of direct action. Number two, based on the structure of this code, we will mainly cover those problems that we are faced with right now in our reality while applying or enforcement of legislation or the application of laws in the regions. We see different types of specific actions applied in different provisions. And in order to have it unified, that's why we have this code. Depending on the regions, they apply different way of establishing business, and a lot of benefits are being provided due to remoteness of those areas. Like Republic of Karakalpakstan, they have strong benefits, for example. And also in the steppe area of Navai region. So they have their own benefits in order to attract business investments to those territories. In general, it is an ongoing process. Right now, we are at the initial stage. I have to mention that as well. So right now, we have specific timeline, and as soon as the first draft will be prepared, we will definitely provide it for public discussion. We will have a lot of discussions with experts. We would really look forward to obtain expert opinion. And thank you very much for the interest expressed with regard to that matter. Rustam Kurultayevich, thank you very much for your response. If you allow me, we have another question. We have interpreters, they will interpret it from Uzbek. Good afternoon. I have a question with regard to artificial intellect. So instead of lawyers, can we utilize artificial intellect? Do you know how much time will it take for the artificial intellect to replace human intellect? That's to the Minister of Belarus.
Muzaffarga eshitmadi shekilli, boshqatdan maqib olsangiz. Avtomatim перевод bo'ladimi?
Yes, the simultaneous interpretation is provided.
Здравствуйте, уважаемые эксперты.
My name is Azam Erkinov. I work at the Ministry for Justice. Good afternoon, everyone. Within recent years in the Republic of Uzbekistan, systematization of legislation is truly the priority for us. And we know that in Belarus, you've performed already comprehensive systematization of the laws of the Republic of Belarus. So my question is to the Minister of Justice of the Republic of Belarus, could you share with us what are the modern methods for that systematization has been applied while developing your establishments, and what are your recommendations to our country in this regard? Thank you.
Олег Андреевич, вопрос.
Have you heard the question? Sergei Zadiran, I am the first Deputy Minister of Justice of Belarus. Oleg Leonidovich has been called upon to the government, so he kindly asked me to represent Belarus right now. Unfortunately, we have some communication problems. So as far as I understood, the the matter that you are asking about is the matter of systematization of the law that we have.
So I'm wondering what present-day techniques have been used in the systematization of the legislation of the Republic of Belarus, because we are aware that recently you finished comprehensive systematization of legislation. So the legal documents of the Republic of Belarus have been recently systematized. Thank you for your question. Let me answer. So the issues of systematization and, in principle, transformation into the digital space of all rule-making processes. So this is dealt by separate agency, the Legal Transformation Center, and if you know the national system of the Republic of Belarus in this area. So this agency is not part of the Ministry of Justice. They do not report to us, but they are our long-standing partners. I will answer this question because the major role in systematization has been played by all legal electronic systems we have started using. If you are interested, then the departmental rulemaking area as a whole several years ago was digitalized, and we are working using the integrated digital system DBR. And if you're interested, we will give you more information on this issue. And starting the 1st of April, we've been trying to work with documents higher level draft laws, and they will be submitted using a similar electronic system before they are considered by the government, and given the so before finalization of this digitalization process, we are focusing now on these electronic resources. We are using them now. I hope I've answered your question, but in case you need more clarifications, I'm willing to continue this dialogue and inform our colleagues, engaging our experts from that center. Thank you. Yes, please.
It's Rustamboy. My question is also to Minister of Justice of Singapore. KPI system, key performance indicators, has been introduced into the Minister of Justice Uzbekistan, and it is now in practice. Based on this, employees of Minister of Justice are assessed, and according to its results, they are provided with financial incentives. Well, in connection to this, my question is threefold. First one, which methods does Singapore use to motivate their public servants in the public administration to achieve best performance? Second one, are financial incentives for public servants sufficient to deal with corruption in public administration? And last one, as we know, there are so many ways to combat corruption. So which alternatives does Singapore use to drain the swamp of the corruption, besides, financial incentives, stimulation? Thank you in advance.
Right, thank you. The three questions that you've asked. First, the methods to motivate the best performers. Financial incentives alone, I think, won't be enough. But you do need financial incentives. It can't just be words. It's a combination. You need an entire system starting from the top with the minister, the director general of the ministry. We have a fairly thorough system to evaluate what each officer does in the course of the year. And tasks are given and are cascaded down. The minister sets the policy, says, I want this done. The director general is supposed to get those things done. He works with his officers. Ministers work with some of the officers. And either things get done or they don't get done. And, you know, and feedback is given to the officers. And at the end of the year, they are told, look, this is your performance grade. This year you have done this well. You did these things right. You didn't do these things so well. And of course, bearing in mind there is a natural tendency to give only good news, but not bad news. Not easy to talk to people and say you haven't done so well. But you need a system that's rigorous, deals with these things, assigns performance grades, and then the divisional heads come together because each one may say their officers have done well. So they all need to come together and discuss, okay, who are the best performing officers across the different departments within the ministry. And so it cannot just be a patronage system. And everybody has got to agree that these are the officers who have performed well. These are the officers who have performed slightly less well. And then this group of officers, they need to buck up. And over time, the performances are assessed, reassessed through different superior officers. And each year, based on your performance grade, there are financial incentives can vary between a high grade and a lower grade. And that also determines your career track and promotion. So there is an incentive to do well, keep getting promoted, reach the top. If you don't do so well, either because you don't have interest or it's no aptitude, then really something else is better for you. It's a performance assessment system that tracks your career from beginning to end. Yeah? That's one. Now, that's a system that I've described. I'm not going to tell you that it's perfect. It's run by human beings. There will always be imperfections. But on the whole, it has worked for us. And our approach is to choose the very best in high school, you know, and then give them scholarships to go to university and then bring them into public service. That way, we hope to have the best people here, and you've got to remunerate them. And you've got to be fair in assessing them. And you also, it cannot all be what's the amount of money they get at the end of the year. It's also how you motivate them and what sort of targets they have, how they see their policies being implemented, and do they see the results? Do they feel that they are doing something useful in the interest of the public? The laws, do they get passed? Do they get implemented? Are people's lives changing? Did they have a hand in that? So all these are important. Second, in terms of financial incentives, are they alone sufficient to deal with corruption? No, absolutely not, which is why I talked about you need a strong laws, you need enforcement. But if you only had strong laws and enforcement and you don't pay people properly, then people will be trying to avoid compliance all the time, or you won't get good people. So you must have tough laws, you must have enforcement, but then you must pay people properly. So it's a combination of factors. And if you pay people properly and the higher they go, the better they get paid, then, and they know that they stand to lose all of that, even if they commit one mistake, that's also relevant. So that, I think, answers your third question, ways to combat corruption. In the end, it's an entire approach. It cannot be that, you know, the law has got to apply to everyone, and it's got to start and applied comprehensively.
Thank you very much.
Спасибо, господин министр.
Thank you very much, Mr. Minister. Questions, please. Microphone. First, I wanted to ask question voiced by Mr. Raf, and the representative of the Ministry of Justice of Belarus couldn't hear it. So the question was, how many years do you think it will take for an artificial intelligence to replace lawyers? That was the question. And my question actually is general. To all ministers of justice, we are all aware that the Industrial Revolution has happened. Now we are witnessing the fourth Industrial Revolution, and we are witnessing the animated growth of internet commerce and digitalization. So in such a scale, when no jurisdiction, no state can limit the development of internet or web-based commercial activities. In this regard, there are very serious issues, like how such relations are regulated from the perspective of legal sector. So there are issues of taxation of enterprises operating actively in internet platforms. So they are not registered as a business entity in Uzbekistan or in Russia or in any other country, but they are very active and they generate profits. So how can we fight against such challenges? On top of that, there are also issues of holding liable for dissemination of wrong information, of false information. So such challenges require some steps to be taken by the state to prevent it and to bring such internet-based relations into the legal formalized sector. And are there any initiatives by our country or within SCO or CIS countries, maybe signing any given legal agreement, international agreement with regards to internet security or taxation for internet companies? Thank you. The first question was for the Ministry of Justice of the Republic of Belarus. Yes, please. Thank you very much. If I answer your question literally, most likely never. Artificial intelligence or any other application can replace a lawyer. Understandably, there are such algorithms streamlining operations. They have emerged, they are being developed, and also the digitalization of full automation of rulemaking processes. Yes, they make it easier to process documents, and we can see the stages, we can see the initial revision, initial version of the document. We can see how the document was transformed based on the comments and suggestions received. And we can use electronic signatures. Yeah, we can avoid papers at all, but the initial will of a lawmaker, which implies meeting the interests of all groups when developing a legal document. So here, I guess, there is no other thing that can do that but for human brain, if we are referring to that narrow sector, specialized sector. And as for subsequent implementation of all related procedures into the legal practice, well, I guess it will be only right if some typical decisions, frequent legal issues could be managed by artificial intelligence. That will happen, but anyways, the will and the intellectual ability of a human being could never be replaced by an artificial intelligence. As for regulation of newly emerging relations, for the stakeholders, I will state that the Republic of Belarus, to some extent, is a pioneer in some areas. So I guess many people abroad know this, the so-called decree of the President number 8 on digital development. And we can easily find it in the internet. And its provisions. And actually, all the issues suggested by our experience back then, they were worded and phrased, and we tried to tackle regulation of cryptocurrencies given the format of the meeting. I will skip the detail, but the document is very interesting, and we are aware that in many relations with our foreign colleagues, given the effective legislation, well, our colleagues also referred to that decree number 8, and in case there is the need for regulation, I think we can find ways to resolve such issues. And as for international regulation related issues, I guess we also have the tool to sign international agreements, but so far I guess we are only beginning to understand these processes, but some time will come when such international agreements will be identified. I mean, the ones that could be applied to the areas where new technology is used. Thank you. It will be very interesting to me to hear from the Ministry of Justice of Azerbaijan, Mr. Mamadov. So what will you tell us on that? Dear colleagues, I'd like to welcome you and congratulate you on this forum, but unfortunately our dear minister has received a call, and if it's a matter of principle that the minister responds to your question, we can invite him. But if you're interested in our opinion in general, so my name is Mr. Abdulf, I'm an advisor to the minister. And Mr. Minister, in his message, touched upon artificial intelligence. And definitely in many areas, especially in the operations of the judiciary, artificial intelligence is used. But I will agree with colleagues from Belarus that the machine can never replace a person fully. And so once there was the statement by Deputy Secretary General of some agency, and he said that given whatever digitalization, so this will help the sorry, not the BlackBerry phone, and I guess the final decision will be made by humans, and the information technology makes all our lives and all our work way easier, and it makes it more user friendly. Thank you. Dear Minister, do you have anything to add to your opinion on this issue? Then, with your permission, let us switch to other questions, if any. Before I ask my question, I would like to thank
So first of all, I'd like to express my deepest gratitude, and then I would also like to share my ideas with regard to artificial intellect, because that's just supporting the human capacity. So, and my question, and that's actually a comment. I think that artificial intellect, you need it only when human intellect have to switch to a higher dimension. So then you have to actually still use at a maximum level human intellect. I have a question to Belarus Deputy Minister. So About those personal offices, how did you establish that in Belarus? I've heard about it. So I've heard that in Belarus, coverage of the population with regard to the access to public services via personal cabinet or personal mailbox, it is quite high. So you have the whole program, right, for full coverage. So that's of a great interest for me. Those are quite an achievement. And as far as I understood, every national of Belarus have their own personal mailbox. Well, thank you so very much. Minister of Justice of Belarus, please. Thank you very much for your interest to the experience of Belarus. In response, I'd like to say that a number of activities, events are ongoing, and they are impacting the following direction of our further development. So this year we foresee, well, we have to switch to electronic passport soon. And we are adopting the law on protecting personal data. So it's clear that without all those, without providing security to all these measures, you may not even think about transferring completely to work with our nationals electronically. So by 1st of June, we're planning on establishing so-called individual or personal boxes or cabinets or offices, and we truly want to transfer all administrative procedures to electronic format. So I don't want to, well, the format of our meeting of today will not allow me to dwell on that. Of course, we are always pursuing the excellence, and but step by step, we truly want for our citizens to have opportunity to cover as many as possible public services, to get the services electronically. We're also moving towards the areas where citizens are planning on or performing their entrepreneurship activities. So we now have, several years ago, an opportunity to get registered as individual entrepreneurs, and it's all done electronically, and even some legal entities can be registered electronically. We utilize notary service as a middleman, and because at the initial stage, one of the very have electronic or digital signature, and that's important. So now, let's say at the initial stage, if the citizen is not planning on widely using that instrument, so they may address to notary service to help them with that. So timeline, as I told you, we have several years to go, and then we will have to check it out. We'll have to test our legislation. Will we be able to cycle all these activities, to bring them all together, to bring all the stakeholding agencies to have all of them integrated to one unique and safe and secure system? Thank you. Thank you. Yes, please. Good afternoon. I have a question. My question is to the Republic of Belarus and Azerbaijan. How do you perform legal appraisal, I think? When you apply artificial intellect, at what process do you perform this appraisal, and do you have any software for that? Oh, linguistic expertise or linguistic appraisal.
Linguistic or legal? Yep, linguistic. Well, we haven't approached it yet even. So we are more of the expert level. So the products that are being produced, let's say, or, to have it as, we do have this software as a separate expertise, but it's not applicable yet. Azerbaijan? Thank you very much for your question. In this area, the linguistic expertise, applying artificial intellect in that regard, we don't have it. Mainly, artificial intellect is applied only within the system e-court. The judicial system, which I've referred to, it has been developed together with WB, with the World Bank. I've referred to that, remember, in my report. I think that in future, other parts of activity of Ministry for Justice will be also applying artificial intellect. I hope so. Thank you. Thank you. Thank you very much. Yes, please. Good afternoon, distinguished participants. Ardor Yakubov, my name is. Well, in order to develop proper investment climates, we still have a lot of obstacles. First of all, that's the rates of refinancing rates of central bank. Like in Uzbekistan, it is 14%. Like in US and in Japan, for example, it's only 6%. So that's very good to attract foreign investment. So questions. Will be investment climate better? Well, can we, if the refinancing rate will be reduced down to -6%, will this increase the attractiveness if we will become an offshore area or tax haven, to have the tax haven in Uzbekistan? How about establishing free trade zones? Will it also be better for Uzbekistan to become free zone for Central Asia or for CIS countries or even globally? Will these four indicators improve investment attractiveness? I'm asking Minister of Justice of the Republic of Uzbekistan and Azerbaijan. If you allow me, I'd like to start. It is very proper questions with regard to investment. So first question, of course, it goes back to banking policy, and banking policy is being developed by central bank. So all these rates are being established by them, taking into account the trade turnover in order to improve and reduce inflation rate. Right now, it is 14%, for example. It was a lot higher. And then inflation targeting is very much important here as well. So, and that impacts, of course, the trade turnover. So the more investments, the better access to capital. So that's the most important thing. That's the axiom. So we're highly interested in having those rates as low as possible. As for the second question, offshore area. Well, we're not offshore. We cannot be offshore. We have our geopolitical position is different. We have completely different economic dimensions. So we have other opportunities to improve and to have full-fledged development to attract investments. In the legislation, we do already have certain restrictions for offshore.
And yeah, we may come up with some other ideas with regard to international business. It will not produce a lot of effect, I may say. As for the free trade zones, you know that there is new law and there are many benefits provided there, up to complete exemption of taxes for 7 years. We have somewhat about 20 free trade areas within recent 4 years. We even have free trade touristic zones. We also have specialized pharmaceutical free trade zones. So this is what we do right now. Besides, for lower industrial areas, we also establish this type of free trade zones to attract business development to these territories. More than 100 small-scale free trade zones has been established within recent 3 years. Well, besides, as lawyers, we have to be quite responsible, and we have to come up with number of decisions to resolve number of challenges. If you are an investor and you are analyzing the state to get your investments to, so for you it is very much important to see if the legislation is sustainable and strong, if there is the rule of law applied, if there is independent judicial structure, business and infrastructure, repatriation of profits. Because you go to the country, you invest to a certain country to obtain better profits, right? So, because you have your own commercial objectives and aims, so that's why you have to have your own interests. That's my response. Thank you. Minister of Justice of Azerbaijan, please. The floor is yours. Thank you very much. It is very much urgent matter. Today, my colleague from Kazakhstan has been talking about investment center. So this area has been established not far from Caspian Sea, and the whole law has been adopted for that. This law regulates a special status of that area, of that zone. They have their own legal space, and it's different from the general legislation. So they have a specific status, but at the same time, we have so-called technology folders, and besides free trade zone, which is completely tax exempt, in so-called tech folders, they have, let's say, beneficial taxation there for them to perform their activity. It's technoparks, I'm sorry. Technology parks. Well, you misunderstood, I think, my question. Right, it is quite high turnover in technoparks, technology parks, technoparks. I think you misunderstood my question, but thank you for your response. My question was a little different. Not about the free trade areas, but geopolitical free trade zones. Not domestic free trade zones, but when we have, let's say, export and import operations or transactions to be performed at one level, to improve diplomatic connections between the countries. So that was the question. So. To be honest, it is more of a political matter, and then it may bring you down to certain unions or assemblies. You shouldn't only look at it from the point of legal aspects or economic legal aspects. In my understanding, it's more of an economic matter. Well, thank you for your comment, but we have to improve our reforms in the area of investments, And then, first of all, we have to reduce the refinancial rates. 14% in Uzbekistan, automatically we are not compatible with even neighboring countries. They only have 3.5% or even -6%. Normal investor, foreign investor, will never invest to Uzbekistan because they know that it's easier and better and more beneficial for them to work in European Union. Last question. Can you describe any example? Can you give us any example of artificial intellect that resolves judicial matters? So Azerbaijan has been awarded, right, for that. One example when artificial intellect produced better judicial decision than a human intellect. And I'm asking Azerbaijan.
Пожалуйста.
Please.
Да, еще раз благодарю вас за вопрос. Очень рад, что тематика.
Thank you very much. Thank you for your question. I'm very happy that the topic of this forum is so interesting for all of you. In a number of countries, artificial intellect, as I told you before, so the main focus is in judiciary. And one of the elements of applying artificial intellect is the procedure of anonymization of judicial decisions. Adjudication is being, we remove personal data, and this anonymization is done before them to be published. At the same time, there are some category of cases, like civil cases, when, with the help of artificial intellect, it is possible to develop a template of adjudication, so on specific cases. So in future, there is a trend, and it's even applicable for different countries.
Значит, применение искусственного интеллекта при...
When we talk about pronouncing sentences based on artificial intellect. But still, all these decisions should be public, and the minister has mentioned that we have a single database for all judicial decisions. So in future, artificial intellect will develop the sentencing guidelines with regard to a specific case, taking into account generalized practice. And I may also say that, as far as I know, in the United States of America, they have a lot of research, and in future, I think that we will be able to apply this example. Thank you. Thank you. Any more questions?
Здравствуйте, уважаемые гости.
Dilafruz Sofieva, representative of the Ministry of Justice, Republic of Uzbekistan. Today, it has been repeatedly emphasized that present-day information and communication technology are very instrumental in lawmaking and rulemaking. The Ministry of Justice of the Republic of Uzbekistan has highlighted that recently the law and legal documents of the Republic of Uzbekistan has been adopted, reflecting present-day techniques, including anti-corruption appraisal. And my question is to representatives of the Ministry of Justice of the Republic of Belarus and Singapore, because these countries are distinct in terms of active implementation of information and communication technology and fight against corruption. How digitalization is used in anti-corruption appraisals? Do you have any examples like that? And the second question is about participation of the public in lawmaking. So what are good practices to ensure participation of various stakeholders in lawmaking process? This is also some sort of a feedback, and direct participation of stakeholders definitely is very positive. contributing to more effective legal documents, draft legal documents. Please. Ministry of Justice of Belarus, is the question clear? Yes, it is, but again, in the very beginning we had some technical issues. If it's the question to us, we will be happy to answer. So as for procedures for using various technologies for anti-corruption appraisals, well, starting the 1st of April this year, we've been using a separate system which covers all entities in rulemaking and all stages for legal documents development. And anti-corruption appraisal is no exception. Again, it will go digital using that system, and since we have only started doing that, and quite recently we have only started using it, and I guess as for some generalized experience related to benefits and disadvantages, well, we can present it in subsequent form because we have only started doing that. As for participation of the public in discussions, we have quite a few tools enabling us to take into account various opinions, and one of such tools which have long been in use is establishment of the so-called public advisory councils under the justice agencies and under the Ministry of Justice. We also do have such a council, and mostly we discuss issues related to business development and the areas within our competence. And if there are drafts envisaging totally new approaches to legal regulations or target broader business environment, well, we get engaged in that. And as for discussions of draft legal documents, we have the procedures established by the government. We have the open platform, which has become very popular, and representatives of the legal entities, individuals can discuss the draft legal documents, submit their comments, suggestions, and this tool is broadly used in our country. So these are the key points. Thank you. Ministry of Justice of Singapore, please.
I think the answer has been quite comprehensive. I would go back to the earlier point that I made. To me, what is the philosophy towards corruption? What is the philosophy towards anti-corruption? Is there a determination to see zero tolerance? And if there is, then it's straightforward. I mean, it's a question of having the right laws and enforcing them. And at the same time, being sensible about having the right policies to make sure that people are adequately compensated too. So it's a combination of policies. But the first and principal question is there political will to make sure that there is zero tolerance?
Спасибо.
Thank you. With your permission, time is limited. Yeah, we can see a lot of questions, a lot of challenges. But this session alone is not enough to address all of the questions. We have other sessions, and on behalf of the Ministry of Justice of the Republic of Uzbekistan, I'd like to thank ministries of justice of other countries for, I'm grateful to their teams for their time, and I wish them every success Best of luck.
Sizlarga ham kattakon rahmat. Sog' bo'linglar. Rahmat sizlarga.
Switch on camera.
Assalomu alaykum, hurmatli Tashkent Law Spring.
Distinguished participants of Tashkent Law Spring, I'm happy to welcome you online and offline in Uzbekistan. There are ongoing reforms, and further economic development of the Republic of Uzbekistan is truly based on further development of intellectual property of the country. So in 2019, the Republic of Uzbekistan has accessed 3 international conventions, that's the protection of intellectual rights and property. And next year following, we were able to establish, there was this agency on intellectual property that has been transferred under the Ministry of Justice. So number of MOUs and number of documents has been developed and signed. So we've developed the number of rules on intellectual property. So the agency on intellectual properties do perform a number of very important activities. Recent monitoring has been developed and has been conducted, and in 2021, in January, the president of our country has adopted a separate resolution on protecting intellectual property. So all the ministries and committees and agencies and also local municipal bodies, they've got certain obligations to perform. So entrepreneurs and producers has obtained a number of benefits. Right now in Uzbekistan, it is the whole war against counterfeit products. And we have legislation enforced in that regard. So we've established a separate network system with regard to the intellectual rights and a number of related rights, etc. So just recently, there were open discussions going on, and we were able to discuss a number of matters. So I truly think that there will be a continuation of a very interesting topic. We have representatives of the agency here under the UN. Also, we will have Ljubljana University presentation that are dealing with the matters of intellectual property, and I truly hope that we will have vivid discussion. First floor goes to our close friend. So that's the World Organization on Protecting the Rights of Intellectual Property. They will provide us with the information which will be another proof that we are part of one family, where all and everyone is highly interested in protecting the rights of intellectual property. New trends will be also revealed in approaching this area. Mr. Gribkov will have his presentation regarding trends in the area of protecting the intellectual property rights. He worked in the area of Central Asia and the Caucasus. Please. Thank you very much, Mr. Abdusatarov. I have a delay, and I have some background echo. Do you hear me well?
Прошу слышно, Илья. Можете продолжать.
Yeah, we can hear you well. We can also see you well.
Пригласили нас принять участие в
Thank you very much for extending the invitation to be part of this event. I was so happy. It's my second time of participating. So like 2 years ago, I was able to be part of that in person. Unfortunately, current realities with pandemic did not allow us to visit your beautiful country and beautiful city. I truly hope that one day it will all be ended and we will have great opportunity to personally communicate and discuss all these matters. To be frank with you, since the topic covers the fourth industrial revolution, in my report, I wanted to cover certain matters which are linked to new technologies which are applicable by the World Organization on Intellectual Property, and that is being provided to consumers for their comfort. So let me share my screen.
Вы видите презентацию?
Can you see it? Yeah. Okay, let's continue. Here's what I would like to say. First of all, my best congratulations with the Day of Intellectual Property. Well, the topic of this year's forum is very much important: commercialization and small and medium enterprises. So, General Director of our organization has emphasized that small and medium enterprises do move forward the progress. They develop both job places and consumer goods. So that's why it is very much important that this topic will be linked to small businesses and medium-sized businesses and the way they apply intellectual property. I would also like to emphasize that truly innovations and technology, those are two main things which are of a great importance that we have while witnessing the fourth revolution, industrial revolution. So what do we mean by that? So first and foremost, everything that is connected to artificial intellect, large data, and other products. What do we have under the World Organization of Intellectual Property is that which we may provide for your to be used, and then what has been developed based on advanced technology. First of all, it is the system of translation, automated translation, or so-called machinery translation. Private persons are applying that as well. So new technologies are being developed in searching images. Especially, it is very good for the trademarks that simplifies the search at the market of those registered trademarks and makes our life so a lot easier. So, and then consumers are able to select their own specific trademarks, and the system of speech identification is being developed, and also classification. When I'm talking about translation, indeed, first we have to say that we have a strong database wrapper, which works in 10 languages, that allows quite rapidly translate even paragraphs of applications and also other texts. So this system works based on artificial intellect. So it is self-educating. So currently, a lot of users do apply this program. So based on new technologies, we were able to develop our new system, wiper-proof. So this system is very much needed for the consumers because it helps to register that this or that file or creation has been generated and been in existence for a certain period of time. So any author or inventor can obtain a token online, which will be needed for him, and it can be used in the court, because in that particular area, so this system wiper-proof, they are accepted at the international level.
That's why new technology helps us in this area as well. We also continue However, in the area of publications on the key trends in technology development, and as part of that series of publications, research was carried out in many aspects, mostly with regards to the technology and the patents submitted on new technology. For example, our first research was the report in 2019 on artificial intelligence. Back then, it demonstrated an increase in the number of applications. So since 1950s, more than 340,000 patent applications have been submitted, and more than 1.5 million publications on artificial intelligence have been submitted. And there are 5 biggest applicants: Toshiba, Samsung, Microsoft, and others. If you take a look at the chart, so the number of applications peaked in 2015, and so the topics mostly included machine vision, automated analysis of video information, but mostly in robotics. So the increase is 265%. That's huge, and much attention globally is being paid to present-day technology and its use. Naturally, our organization had to focus on such important changes ongoing globally, and that's why we continued our studies. And the next study, which was published quite recently, is on assistive technology. And it's a new study, and frankly speaking, based on its findings, we got very important numbers suggesting an increasing role of assistive technology in our world. What we mean when we are discussing assistive technology is, for example, the technology implying embedded environmental cognitive technology. In fact, we use it daily, and we pay almost no attention to the cases when we are using them, namely the technology of the smart house or robots helping us, or technology which is related to hearing, mobility. And what's most interesting is the conclusion that is drawn about this, namely the number of applications related to assistive technology has increased considerably compared to the number of applications submitted with the aim to improve some models in the area of motor activity, for example, wheelchairs for the disabled. And even in this area, the technology associated with new achievements using smart technology, so their number is way higher. And strangely, and I've mentioned that, the main drivers in this area are universities and think tanks, and is for using new technology. Universities account for 23% of applications, while traditional technology, as for that, only 11% of applications are submitted by universities. It's an important point because currently As for commercialization, modern technology is more important, and that's why we pay more attention to that as part of the fourth industrial resolution. So we pay attention to these technologies. And the World Intellectual Property Organization, we keep discussing this technology. And in 2019, the discussion was organized to discuss what this technology is, how we can apply it, how we can use it. And that's why we organized 3 rounds of discussions. In principle, the results of discussions are available on our website. If you're interested, you can take a look at them. In particular, we sent a questionnaire for consultations with various participants, member states, and companies, and we got a lot of comments, and they have also been posted for a discussion. Since so far, we keep facing modern technology like artificial intelligence, Internet of Things, and others. So we have to pay attention to that, and we will keep on doing that. In this regard, I'm pleased to note that Uzbekistan this year has arranged the discussion of this very topic. And I'd like to say we are willing to cooperation. Thank you. In case you have questions, we'll be happy to answer them. Thank you. Mr. Gribkov, with your permission, I guess we will have questions and answers after we finish all the presentations. And now I would like to give the floor to our next speaker, Lorenzo Montanari, Executive Director of the Property Rights Alliance. Please.
Presentation?
No.
Yeah, I can see it. Okay. So good morning, everyone, and thank you so much for the invitation to this prestigious legal forum, and I really appreciate for your commitment in defending property rights. I want to start my presentation with this quote from Frederick von Hayek: "The system of private property is the most important guarantee of freedom." And this is we always like to highlight this important quote, because we think that the property right, like intellectual property right, are the backbone of any free market society. Property Right Alliance was founded in 2005 with the mission of defending and promoting rule of law, property right, and intellectual property right all over the world. For this reason, we developed the International Property Right Index in 2007, thanks to the partnership with Hernando de Soto, the Peruvian economist that is advocating for property right protection all over the world in the last 30 years. The economist behind the index is Professor Sara Levi-Carciente from the Boston University and the Central University of Venezuela. And I will show you quickly the framework of the index that is basically focused on three main components. We analyze more than 129 countries, and we have a huge network all over the world of a different think tanks, more than 120 think tanks. This is our network from Afghanistan to Venezuela, and we cover more than 70 countries. The framework of the index is basically we collect data around three main components: the legal political environment, the physical property right, and the intellectual property right. You can see the legal political environment is divided in different items: judicial independence, rule of law, political stability, control of corruption, while physical property right is focused on a perception of physical property right protection in each country, registering property, and easy access to loan, while intellectual property right is the perception of IP protection on the people, patent protection, and copyright piracy. Methodology is the equal component, is the equal division between the legal, political, physical property and IP. The scale goes from 0 to 10. So 0 is the worst performing country, 10 is the best one. We don't have 0 and 10 in our ranking, but this year we try always to collect more data as possible to include more countries. This year we lost in terms of data, Sierra Leone and Liberia, and we got 2 countries, Madagascar and Gabon. You can see very quickly that from 2016 to 2018, there was a positive trend in terms of improving quality of protection of property right IP, while from 2018 to 20, there is a light decline in terms of protection. And in some, this decline is also, we will see in some slide later, is focused on also in advanced economy. This is the ranking for the 2020. Finland is almost leading the country as the best performing country, while Haiti, Yemen, and Venezuela are unfortunately the worst performing country. The average score for the EPRI in 2020 is a 5.73. For legal political environment is a 5.14, physical property 6.50, and IP 5.55. You can see that it is very important to say that the average per capita income is in country where the strong protection of property right is 16 times bigger than the bottom country where the protection is very weak. Finland and the United States are leading as the best performing country in terms of protection of intellectual property right. You can see very quickly the top 15 and the bottom 15. We can see that in the top 15, there are a lot of European country, North America, and some Asia like Singapore, Japan. And while in the bottom 15, you can see that most of them are some Asian country and African country, as well as Latin America with Venezuela and Haiti. In the next slide, I will show you our data divided by geographical region. You can see that in each slide we confirm the protection of property rights. Strong protection of property rights means a strong economic development. And we can see that the European Union, North America, and Oceania are the best performing region in terms of protection of property rights. Same for the income group, high income country correspond to the strong protection of property right. Same for the, we divide our data and we analyze according to integration agreement. You can see OECD country, European Union, USMCA are the best performing, or EFTA are the best performing country with a strong protection of, thanks to the very important free market agreement. We also analyze our data through, let's say, different groups, productive drive, underlying condition, human mobility, digital society, and health and life. And we discovered that comparing our index with the more than 20 other index, there is a strong correlation with our index in property right with the Global Biotech Innovation Index, as well as with the Global Competitiveness Index. This explained that property right remains a crucial element for the fourth industrial revolution to boost economic competition among countries, and also with the Prosperity Index. And here some slides regarding the country. Finland, as I mentioned, is the leading country in the world, number one globally and in the region. Despite that, there is a slight decline in the score, but there was an improvement in terms of protection of IP. This is just to give you an idea of the quality of protection. United States, number 13 in the world, number one in the region. Even in the United States, there is a slight decline in terms of general score. And here, Georgia, we put Georgia in the Central Eastern Europe and Central Asia. There is a kind of a decline in the protection of property right, but I want to highlight that Georgia is one of the few countries that has scored 10 in registering property. This is very interesting how Georgia is moving forward on protection of a physical property right. You can see the graphic, how different it is with comparing Finland and United States. Save Azerbaijan, number 67 out of 129, number 13 in the region. In this case, we see an improvement in the general score, and also in Azerbaijan, there is interesting data regarding registering. And here at Kazakhstan, number 85, and globally and in the region, number 17. Even in this case, there is an improvement last year, strong protection in terms of registering property. There is, unfortunately, lack of data in the main Central Asian country. And this is something that I want to highlight because we are really looking forward to collaborate with this country, like Uzbekistan, to collect data and to add this Uzbekistan, like other Central Asian country, in our index for the 2021 edition. So please contact me for if you are able to give us data on around our component. So just I want to find a remark about the index, and after we're going to talk a little bit about IP and cybersecurity, but I want to highlight that EPRI proved again to be a valid instrument to evaluate the performance of a nation looking for improvement of the well-being of the population. Again, our index highlight the importance of protection of property rights tied to the economic development in each country. And we recommend also to any policymaker to think about implementing property right reform, also using our index. It's not the only policy tool, but at least we provide also, let's say, a data regarding the legal and political environment that is extremely important to implement protection of physical and intellectual property rights. Our index has been used by Forbes, Financial Times, Economist, different international organizations, at least for what concerns the raw data behind the index. I want just to highlight very quickly the importance of intellectual property rights. So the raising of the intangible asset in the last 30 years against tangible assets. You can see very quickly how in United Kingdom from 92 to 2014, the intangible grow compared to the tangible. Same for United States from 48 to 2008. It's very important to see how the upcoming fourth revolution has been developing constantly from the 48. Same for the European Union, you can see the graphic, and in terms of investment with the leading innovator, a comparison between the United States and the European Union. And again, very quickly, just to bring an example of the European Union, just to show why IP are playing an important role in the economy. You can see that IP-intensive industry employ 39% of the European workforce and 30% in the US. And this job generate more than 40% in GDP in both economy. Just to highlight some number, why each country should move forward on IP protection, because this is the only way to create a strong economic growth. Another example of which inside the IP group, trademark are the leading in terms of design and copyright. And they asked me to speak a little bit about cybersecurity. I mean, we know perfectly that in the digital economy, cybersecurity and fraudster are the bad player in our new digital world, because undermine the innovation and creativity of inventor, negatively affect the economy, and also pose a threat to national security interests. And in fact, there are different reports that I will invite to read. I'm happy to share with you. I mean, the 2018 FBI report know that the trade secret theft from China account from 2025 to 600 billion lost annually. Or, for example, in terms of national security, in 2018, the Department of Justice indicted the Chinese telecommunication company Huawei with the trade secret theft, wire fraud, and obstruction of justice, and so on. Up to fake CDC vaccine, that is basically the card that the US government provide to everyone got the vaccine. So even this, we find also fake vaccination card, just to give an example. I invite everyone to also to take a look of this global security index. It is not our index, it's the index provided by the International Telecommunication Union, very useful to analyze how each country is performing in terms of protecting themselves from the cybersecurity attack. We can see that Uzbekistan is moving very good in this index. You can see that ranked number 3 with a good score inside the CIS region. And this is confirming also how the government of Uzbekistan is moving forward in the right economic reform and also in intellectual property right reform. Uzbekistan is number 52 in this global security index out of 175 countries. Again, we didn't have a data from Uzbekistan, but I want to highlight that the Constitution of Uzbekistan 1992 protect property right in Article 36 and 53, 54. So is basically is in line with the Universal Declaration of Human Rights by the United Nations, Article 17, even also Article 727. So just to highlight, important reform has been in place in Uzbekistan recently. Has been signed the Convention for the Protection of Producer Phonogram against unauthorized duplication of their phonogram in 1971. So that's became effect in 2018, but also the signature of the WIPO copyright of 1996 and so on. So this is very important because I'm sure we will be able in the future to get more data and include Uzbekistan in our index. And we are really looking forward to work with any agency. I want to conclude and also, of course, congratulate WIPO organization for doing the great job they're doing since their foundation. And I want to invite everyone to join the policy webinar that we are organizing on April 26th, Innovating the Future, celebrating the World IP Day. As a Property Right Alliance, we organize a coalition letter. This year, we were able to collect more than 100 think tanks all over the world in favor of innovation, intellectual property right. And we support, of course, this year, the theme of WIPO. And we will have the Matthew Bryan, the WIPO Director for Patent Cooperation Treaty. We will have Andrei Yanku, former Undersecretary of Commerce for Intellectual Property Right and former Director of US Patent Office, plus Professor Park and Krisa Kozoy. It will be also an opportunity for us to present the first edition, update version, of the 2021 Trademark and Patent Index. So it will be very important to see a ranking all over the world. This is a new index that's been updated by Property Right Alliance in partnership with Professor Park from the American University. We'll have Philip Thompson presenting the letter, and also Seth Hayes is the Chief Representative for Asia and Pacific for the International Trademark Association. I want to thank everyone. This is my data. Please send me an email if you want to participate to the webinar on April 26th, and really looking forward to work with you. Or we are happy to share the data behind our index. So please send me an email and we will share for free the data. And follow us in Twitter, PR Alliance and Lorenzo Montanari, and the index, the full index is in the website, internationalpropertyrightsindex.org. Thank you so much.
Thank you very much for this comprehensive presentation of yours. And all these indicators are of a great importance for us. Thank you very much for this great work that you do, and these indexes are very much correct, as it was mentioned already, that index unfortunately is not covering Uzbekistan, but we are hoping that soon we will be able to share it with you. But it also gives us an opportunity to reveal all the gaps that we have. It covers all the areas, including judiciary as well, so and legislative area. So within recent years, we're trying to do our best in collaborating with Axel, which is involved within the area further development of judiciary or taxation area in our country, and to build capacity of our experts and our professionals in certain areas. So within recent 3-4 years, we will be amending several codes in this regard. But at the same time, first and foremost, we truly want to all the efforts in achieving world standards and to meet international standards. So for that, we will have to develop a special system in certain areas, improving activity in that regard. And we may be quite open with you, saying that we started to contribute and we started to reform this area as well. Thank you. Next floor goes to our next speaker. Countering counterfeit products, existing practices and new challenges, ex officio and customs enforcement of intellectual property rights. So legal advisor, building respect for intellectual property division, WIPO, Mr. Samer Al-Tarawih. You may start. We see your shared screen. We see your slides.
Sorry. Unmute myself. First of all, I would like to say that I'd like to join you in this important event. My name is Samer Al-Tarawih, legal counsel with respect for IP in WIPO. The main part of my work is related to capacity building and digital assistance. Unfortunately, the scope of my subject is so broad. However, I have a very limited time. Therefore, I would need to ask you all to fasten your seat belt, and my apology in advance for the interpretation. My intervention, my presentation today will be divided to two main parts. The first part is identifying the challenge in terms of scope, financial impact, and negative impact on consumers, public authorities, and right holders, where the second part will focus on the best way to fight counterfeiting and piracy. If I would have time, I will provide an overview on the crucial role of customs. The main challenge is the global growing phenomena of IP infringement, particularly trademark counterfeiting and copyright piracy. Historically, this challenge was limited to commodities, products such as clothes, bags, shoes, and some expensive products within this category. However, these days, no industry could avoid this phenomenon. An example of an industry commonly affected by counterfeiting and piracy is within the copyright sector is music, films, software, and video games. In trademark sector, unfortunately, more than before, these days, pharmaceutical products, for example, medical masks, surgical masks, detergent, spare parts, coffee, drinks, shampoo, you just name it. I don't think there is any product these days is away from this. As for the financial impact, and here I would like to thank my friend, the first speaker, Lorenzo, and to add some of the studies that I have to his studies by saying that there are many studies dealing with this subject in a detailed way. And sometimes by the type of fake goods, or by region, or by physical or online markets. However, in my presentation, I would limit myself to one study, which was conducted in cooperation with the European IP Office and the Organization of Economic Cooperation and Development, OECD. This study released in 2016 and revealed that the estimated total value of imported fake goods worldwide was $461 billion in 2013. This study was updated in March 2019 to reveal that globally, the total value of imported fake goods is estimated by $509 billion in 2016. As a result, the updated study shows a 3.3% increase compared with 2.5% of the global imports in 2013. And this part of the studies, I provide the link so you can check them if you are interested. And this study is specifically on pharmaceutical, fake pharmaceutical drugs. Yes. I would like to share this slide with you, as I believe this slide illustrates how counterfeiters look at things. While the whole world sees the current situation of COVID-19 as a pandemic and requires global cooperation and coordination, counterfeiters simply see it as an opportunity to generate profit, regardless of the consequences. In this specific case, counterfeiter took advantage of humanity's need to find a way to fight this pandemic. They deceived the public by advertising that they have a cure vaccine to COVID-19, which was approved by the World Health Organization, WHO, and recipients need only to pay the shipping cost, which is $4.95. This widespread advertisement forces the WHO to come out saying that until this moment, there is no vaccine for COVID-19. This is just to illustrate how things work in their mind. Now I will move on the negative impact of counterfeit and piracy, mainly on consumer right holder public authorities. As for consumers, simply by utilizing counterfeit products or pirated products would deceive the public with the consequences of a minimum loss for money and or puts a human life at risk, death or deformation, due to using counterfeit pharmaceutical products. And here I can refer you to one of the studies that I've mentioned in my slides related to pharmaceutical, which confirm this aspects. As for the right holder, clearly unfair competition, the minimum costs for right holders are much higher than any counterfeiter because they have to pay minimum wage, social security insurance, and many other privileges to their employee, where counterfeiters do not share the exact cost, and they rely on illegal labor to do their work. And we just saw now by our previous speaker how labor force related to intangible or intellectual property in the EU represent 30%, where it is 39% in the US. So such things also would have an impact on the unemployment percentage. Of course, also there is an impact on the brand value and reputation. The value of the trademark due to continued infringement will be devaluated. As for public authorities, negative impact on innovation and creativity, taking into consideration that countries are moving towards a knowledge-based economy approach and discouraging international trade and foreign direct investment. Also an impact on the transfer of technology and could strengthen criminal networks and losses of revenue and taxes. And we know people who's coming from developing countries, they know how the importance of revenue to the general budget of the country. The second part of my presentation will be try to identify the main elements which will help in fighting counterfeit and piracy. And I will start by awareness raising. Simply refer to the economic concept of offer and demand. And in this case, offer would represent counterfeiter, where demand would represent consumers. And simply saying, if there is no demand, there will be no offer. So if there is no consumer that want to buy a fake goods, there will be no offer for a fake goods. Therefore, governments must deal with the demand part first, which could be done by changing the behavior of the consumer, by illustrating to them the negative impact of buying fake goods on them, on their economy, on innovation and creativity, compared with the positive impact of purchasing original goods. Only if they are aware of the negative consequences of buying counterfeit and pirated goods, they can stop this behavior and reduce or eliminate the demand part. However, for governments to create public awareness, they need to have a comprehensive strategy to fight this phenomenon. To have such a strategy, the government needs to understand the reason behind this attitude or consumer behavior in purchasing counterfeit or pirated goods, type of goods that they are purchasing, the age category, who buy what. Such information would allow the strategy to be more focused on a particular age or a type of goods. Also, educational awareness raising initiatives that help equip the young generation with knowledge and understanding of respecting others' intellectual property and developing their own is a key goal in raising awareness. And I recognize that the IP Office of Uzbekistan recognized the importance of awareness by introducing some initiatives related to awareness raising, such as the streaming of series of the great leader Jalaluddin al-Khwarizmi, and another initiative related to or titled 1 month without buying counterfeit and pirated goods. The other part which would help in fighting this phenomena would be enforcement of IPR. Although many international treaties deal with IPR, yet those treaties have few general enforcement provisions. Those treaties such as Paris Convention, Berne Convention, WIPO Copyright Treaty, and WIPO Performance and Phonograms Treaty, which of course Uzbekistan is member to. However, the only treaty that includes a detailed, comprehensive enforcement provision is the World Trade Organization Agreement on Trade-Related Aspect of Intellectual Property, the TRIPS Agreement. The enforcement provision are around 2/3 of this agreement. Although Uzbekistan is not yet a member, but Uzbekistan since '94 is negotiating accession to the WTO. So although it is not a member, they are not bound by the enforcement provision. However, we believe it's only logical when we discuss enforcement provision to make a reference to the enforcement provision of the TRIPS agreement, as they are very relevant, and also, as I said, they are a comprehensive provision. They also, to add to that, that there is right now 164 countries member to the WTO and bound by these provisions. Also, there's 25 countries having the observer status, including Uzbekistan, which means they are in the process of joining this treaty, which means that there is an acceptance to the enforcement provision, including in this treaty and the TRIPS agreement. I will try briefly to go through the main provisions related to enforcement, and I will start by the general obligation and civil procedures, which are covered by Articles 41 to 48, where countries have to ensure enforcement procedures are available under their national legal system to permit effective action and against any act of infringement of IPR. So these procedures need to be fair and equitable. Also, these procedures need to provide for the right of representation. Also, the defendant is entitled to substantiate claims and to present all relevant evidence. Also, it should provide for appeal against judicial or administrative decision, and procedure to protect confidential information. Also, injunction to order party to desist from infringement, damages to compensate the injury, destruction or disposal of infringing goods, material, and implement. Then I will move to very important provision, which is provisional measure, or it's called interim injunction, and in common law system countries called Anton Bella order, which is provided by Article 50 of the agreement. And this provisional measures provide, or this provision allow the right holder to request the court to issue an order to prevent infringement or to stop it, including an order to prevent entry into the commerce of imported goods immediately after custom clearance. Also, to prepare relevant evidence in regard to alleged infringement. Also, the court can issue such a decision without notifying the alleged infringer if the delay would cause irreparable harm to the right holder, or there is a demonstrable risk that evidence will be destroyed. Then I'll move to the criminal procedure provided by this agreement under Article 61, which provides that members shall provide criminal procedures and penalties to be applied at least in cases of willful trademark counterfeiting or copyright piracy on commercial scale. And here I would like to make reference to footnote 14 of Article 51, which provide a definition of what constitutes trademark counterfeiting goods or copyright pirated goods. Also, I would like to make a reference to the report on disputes between the United States and China under the WTO, which also provide some clearance to some of the legal terminology provided in this article. For example, what do they mean by willful trademark counterfeiting or copyright piracy on a commercial scale? Why I'm saying this, maybe at this point I should also say that the TRIPS agreement provides for a minimum standard, which means member states can go beyond the provision in this agreement. So when you want to implement the criminal procedures, you should define what is the trademark counterfeit or copyright piracy in order to differentiate this against the infringement in general. Then I would like to say a few words on effective enforcement, which is a bit different than enforcement, because some countries, they might have an update legislation on IPR, but still they don't have an effective enforcement. And effective enforcement would require legislative and institutional reform in addition to the awareness raising strategy. The legislative reform is not limited to IP legislation, as many provisions might exist in civil or criminal acts or civil and criminal procedures or customs law. Also, building the capacity of the main player in the case of enforcement, such as member of the judiciary, prosecutors, police, customs, and enforcement officials, which usually done through workshop or training, physical or online, through National Training Institute. Of course, WIPO will be more than happy, and it's already provided some capacity building activities for Uzbekistan, in which we tailor the program to meet the needs of the participants, whether they are judges, prosecutors, or enforcement officials. Also, effective enforcement would require to promote cross-regional and inter-agency coordination and cooperation. For example, online information sharing central platform between administrative enforcement and judiciary. As we know, each administrative agency is responsible for implementing their laws, but effective enforcement requires full cooperation among them all. Therefore, regular communication and on IPR enforcement is vital. Many countries, they decided to establish a steering committee which represent all the administrative, all the enforcement agency, in which they can meet on a regular basis to discuss challenges that they have, and they cooperate in enforcing intellectual property. If I would have time, briefly, I will go to present the border measures provision available in TRIPS agreement, particularly in Articles 51 to 60. And those border measures, these provisions aim to prevent infringing goods from entering into the market. And these procedures are limited to imported counterfeit trademark goods or pirated copyright goods. These procedures require that the right holder submit an application to the custom authorities with evidence of prima facie infringement in the country for importation. The customs authority may require security to guarantee any abuse. And once custom authority decide to suspend the release of the goods, they should notify the applicant, importer, and consignee. The initial suspension period is up to 10 days, which can be extended to another 10 days. And if the right holder did not submit any proof that he started procedures on the merit of the case, or he did not obtain provisional measures, the customs can release the goods unless there is, or unless they can rely on any legislation to continue the suspension of the goods. Also, and this is the custom can react without a request from the right holder, but this is optional. Why custom? Why we focus on custom? As
O'zbekistondagi eng dolzarb
Thank you very much. In line with the resolution of the President adopted 1 month ago, under the agency, special department was established, as well as the office of the agency in the Republic of Kyrgyzstan, Pakistan, and also in provinces, special teams were organized. And in Uzbekistan, actually 89 to 90% of goods, I mean counterfeited goods, were identified in Uzbekistan. And it means more than 1,000 types of counterfeited products were detected. So more than 150 types of such products and more than 300 products, producers of such goods were notified and respective administrative documents were initiated so such cases could be. So annually, starting 15th of February to 15th of March, as presented by our speaker. So it is declared as the month without counterfeit products. So our local services and anti-monopoly centers, they cooperate with customs and detect such products. In principle, the work continues all the year round. So as for ex officio, so it's also an important issue, and it's being discussed in our country as well, and we have some developments to introduce the ex officio concept into our local legislation, and definitely your recommendations and your opinion will be of use to us. The next speaker, with your permission, I would like to give the floor to he will inform us on the digital environment, Mr. Thomas Dillon, representing the IP department, WIPO, please.
Be invited to participate in this conference. I came to Uzbekistan on a WIPO workshop in 2018 and had a marvelous time. I hope that at some stage we'll be able to return to our normal way of working. But in the meantime, we are online, and it's my pleasure to present to you on the subject of the digital environment. Can I just confirm that my PowerPoint is visible?
Not yet.
Not yet. Let me just try again. Right. I don't think I did it right. Is it visible now?
Yeah, yeah.
Fantastic. Good. All right. So before I get into details, I'd like to make a general remark about infringement and the internet. There has been a collision, as it were, of different factors, which has resulted in enormous amounts of infringement through the internet. First of all, on the copyright side, you have the digitization of entertainment products. It really began with the music CD in the 1980s, and then you have the DVD or audiovisual in the 1990s, and then the internet came along, the perfect method of transmitting products around the world, results massive online piracy. Similarly, with trademarks, the possibility of e-commerce across borders, facilitated by very efficient courier and postal services, means that also there is an enormous international trade in counterfeit goods, as explained by my colleague Samer. Of course, trademarks, trademark goods cannot be downloaded as such, but of course the order can be placed online, and then, as I say, the efficient international couriers will deliver the counterfeit goods within a very short time. I'm not going to say a lot about counterfeit goods because the principal line of defense against counterfeits is customs, and that has been very completely discussed by Samer and our president. So this is an example of a pirate website, and as you see, a wide selection of films appealing to an Uzbek audience. But before you actually get to access the films, you're forced to see an advertisement. I'm going to come back to that a bit later, because the business model of a lot of online piracy. So I'm going to talk briefly then about 4 subjects. First of all, the basic rights that are implicated by online infringement. Secondly, a practical description of the kinds of online infringement that take place. Then very briefly on the legal remedies. And finally, if I have time, a word about voluntary measures, in particular a WIPO project called WIPO Alert. Now, online infringement implicates rights under the copyright and trademark law, which really do not differ very much from those that are relevant to infringement in the ordinary world, in the physical world. We are talking in the copyright field about the exclusive right to reproduce or copy the work, because internet transmission typically involves making copies, unlicensed copies. And also we're talking about the communication to the public of works without the permission of the author. These are the 2 rights that are particularly relevant when we're thinking about online infringement of copyright. Then in relation to trademarks, there really is no special definition of an internet infringement. One is simply applying the standard test of infringement. Has there been an unlicensed exploitation of the registered mark in trade? And obviously, if you're selling products or importing products that are counterfeit on a commercial basis, you are engaging in trade with trademark infringing products. The key feature of international enforcement is the concept of national treatment. National treatment meaning that the rights of foreign right holders are respected internally in the country in the same way as the rights of domestic right holders. So we find, for example, under the Berne Convention, copyright, that countries undertake to treat other nationals of other Berne Convention members in the same way as they would treat their own citizens. So that, let us say, a song that is written in Kazakhstan is protected in the same way in Uzbekistan as a song from Uzbekistan, and vice versa. And this is how the international framework of enforcement is possible. And we see this reflected in the copyright law of Uzbekistan. You see the reference at the bottom of the screen. In trademarks, again, there is the principle of national treatment. We find this expressed in the Paris Convention on Industrial Property, of which Uzbekistan is a member. There's less to say about that, because when you're enforcing a registered trademark, it's obviously been registered in the jurisdiction. So then nothing very complex in terms of foreign elements arises. So those are the basic rights and the important principle of national treatment. But what do we actually see when we see infringement of copyright on the internet. There are a number of different ways in which the internet is used to infringe authors' rights. And it's important when we are trying to enforce copyright that we have a basic understanding of the infrastructure of infringement, because the distinctive feature of internet infringement is the distribution, the dispersal of the physical elements among several different countries. Very often, different parts of the technical infrastructure will be in different places, and the people who are operating the pirate activity may be in yet other places. So it's the international quality of internet infringement that makes it both difficult and interesting. So the first category of copyright infringing website that I'd refer to are download sites, direct download sites. And a direct download site is essentially composed of two elements. First of all, you have a web page, a website, which gathers together many links to infringing copies of films, music, possibly books, maybe software or games. So you have this website. Then behind the website, you have a computer server in which these copies, digital copies, are stored. And very simply, you click on the link and the digital copy is downloaded from the computer server to your computer. Nothing very complicated about that. So you can see that we have the reproduction right. The right copy is implicated by the making of copies on the computer server. And the right to communicate to the public is implicated by the making available of these digital copies through the website to an indeterminate number of people. And the same story, the same technical story applies in relation to the streaming of audiovisual works, or indeed musical works. In this case, again, you have a website with a series of links. You have a server or a number of servers behind the website which have copies. And with a streaming website and streaming servers, the infrastructure is set up in such a way that when you click on the link, instead of downloading a copy, the work simply plays to your computer and is held briefly in the buffer of the computer without there ever being a whole copy of 100% of the work being downloaded to your computer. So here we have the reproduction right being infringed in relation to the storage of the copies, and the making available or communication to the public right being infringed by the streaming of the work to the public. Now, it's not always the case that the server is under the control of the same person as is in charge of the web, because there are businesses which operate a storage system for the benefit of, in particular, pirates. Now, there are perfectly legitimate online storage businesses like Dropbox or WeTransfer, but there are some which are set up specially to attract infringing copies and then make them available to pirate operators. This is an example where the operator of the storage facility, which we call a cyber locker, is actually advertising that they will pay small sums of money to people who will upload popular content to the cyber locker. How does this actually work? Let's imagine that we have someone who uploads content to a cyber locker. The cyber locker then provides that person with a link which that person can then put on a website. Now, it could be a download website or a streaming website, or it could be in an email, or it could be on social media. People who want to download the content simply click on the link, and then their browsers, their computers, are directed to the cyber locker where the copy is stored, and then they download the copy to their computer. So now everybody has a copy, and probably nobody ever paid for a copy. So you can see that the operator of the cyber locker may not be the same person who runs the website. It's very probably in a different country. And so you can see the potential complexity of investigation of this kind of infringement. A very important form of infringement today is the streaming of live broadcasts, especially sports, because those are of greatest interest when they are actually happening, not when they've been recorded. And this is a very famous website with a series of links, all of them giving you access to live streams of broadcasts. And this works very simply. Someone somewhere has a subscription to a legitimate television service. They capture the signal of the football match or whatever it is using conventional technology, and then they make that available through a streaming server, which is simply a computer, on the internet to anybody who clicks on a link. And quite simply, you click on the link on the website summons the copy from the streaming server, and then the server sends the signal to you at home, and you watch the program as it's being played live on your television. And finally, I should mention the peer-to-peer file sharing. This is still an important form of piracy, though it is to some extent being overtaken by streaming piracy. With peer-to-peer piracy, there is no central server storing the copies. The individual consumers share the copies among themselves using a highly sophisticated software called BitTorrent, or an equivalent software. And in those cases, each of the people who's seeking the content is also sharing parts of the content. But I won't go into the details of that. That's a bit complicated. As my colleague Samer has said, the remedies that you have in the courts are the traditional civil remedies, injunctions, awards of damages, border measures by customs. It's important also to mention criminal measures. And under the TRIPS agreement, it's required to have possibility of imprisonment for commercial acts of piracy or trademark infringement on a commercial scale. Currently, the basic offences, I believe, in Uzbekistan include imprisonment for copyright infringement, but not, I think, for trademark infringement, but I stand to be corrected. So countries have developed a new remedy, which is the site blocking remedy. Because the infringers are very often outside the country, it's very difficult sometimes to enforce against them. But what you can do is order the service providers who give access to the content to your domestic users to block access. So in the normal case, let's imagine I'm getting access to an illegal streaming server. I simply, with the assistance of my internet service provider, I can access this content. Quite simply, the court or the prosecutor orders the service providers not to permit the domestic Uzbekistan consumer to access these particular websites. And that has proved to be a very effective technique for preventing infringement on the internet. So finally, I should talk very briefly about advertising, because advertising is one of the key sources of revenue which allows these criminal activities to continue. And at WIPO, we have developed something called WIPO Alert. It's a system of, or it's a network of cooperation between countries which upload lists of data to our platform, and the advertising industry, which accesses these lists of pirate websites and then avoids placing advertisements on those websites. In this way, they can reduce the flow of money to the websites, so discourage them from operating. It's a way, in particular, of giving international effect to a national site blocking, because you may block a website in your country, but it's still available everywhere else. So we want to undermine the model of these criminals, and WIPO alert is one way to do it. And if anyone watching is interested, please do get in touch with us about it. I think that I probably should end there. I've exhausted my time, but I thank you very much for your attention once again for the invitation. Thank you very much.
Rahmat, juda qiziqarli mavzu uchun.
Thank you very much. It was very interesting information of yours. And yes, I agree with you that, yes, Uzbekistan is trying to do many things in order to stop the counterfeit products to be released in our market. So we work a lot with WIPO in this regard. We put a lot of efforts also in developing our regulations. And we truly want to collaborate with this agency, of course, to strengthen our legislative system and also enforcement. So our next speaker is Bojan Pretner. He's a professor at the University of Ljubljana, international expert on intellectual property, and the topic of the next speaker is improvement of activity of collective management, organization of copyrights and related rights. I truly think that collaboration with these noble experts will provide us with a lot of knowledge in Uzbekistan. Please, I pass the floor to you. You may start your presentation. Спасибо. Спасибо большое. Добрый день всем. Я очень надеюсь, меня
Just a second that since I hear the interpretation. Is it switch off now? Okay. Thank you. Thank you very much. I have the first slide, a little bit different topic, which is about improvement of collective management organizations' activities. This is, of course, something what has to do with copyright and related rights. But let me say that this improvement, or let's say importance of those collecting management organizations, is extremely important also to combating counterfeiting and piracy. Efficient, well-functioning collective management organizations are not important only for this basic task, which I'm going to talk about, but also about combating piracy, because organizations are organizations. They are, of course, much stronger, much more influential than if we talk just about one single physical person who is author of a song or performer of a song, singer, etc., etc. I will try to stay within my 15 minutes, and I will quickly run through everything. We all know collective management organizations, which are dealing with mostly related rights, but copyright, of course, as well. They have been since ever indispensable legal and organizational, I call this infrastructure, within copyright and related rights law. In the era of internet, as we have heard, these CMOs, if I may short listen the name, have gained an unprecedented economic importance. exploitation of creations of authors and performers is growing beyond imagination. But the consequence being an incredibly growing number of CMOs from one side, membership is growing, authors, performers, singers, you name it. And of course, on the other hand, there is an incredible growth of users, radio and TV stations, shops, concerts. Now, all this means that there is a growing complexity in how collecting management organizations, how they manage their three basic tasks. First, concluding license agreements with users, collecting license fees from users, and distribute collected revenues among their members in accordance with agreed rules. Given a large number of both users and CMOs members, there is an obvious need for ensuring a full transparency over their modus operandi, how management of collecting management organizations is performing their tasks. Simply put, each and every collective management organization must work first in accordance with the law, obviously, and equally obviously in accordance with all internal acts of each and every collective management organization. And of course, these internal acts must be in accordance with the law as well, surely. Well, that's fine, principles are simple, but of course, we need also certain institutions or bodies which are in charge of supervising and controlling whether all these collective management organizations do perform their task in accordance with the law and in accordance with their internal acts. So this is, of course, a kind of interface, and this interface between the authorized supervising bodies, this interface has been recognized as a crucial issue. I'm quoting here a nice saying from a relatively fresh EU directive from 2014, and you can see what in preamble this directive says, that there are significant differences in national rules, blah, blah, blah, etc., in particular as regards their transparency and accountability to their members and right holders. There are differences and problems. And equally, other problems with the functioning of collective management organization, which can lead to the exploitation of copyright and related rights in a way which is detrimental to the members of these very collective management organizations. So what this means is that there is a desire to improve how collective management organizations do their business and how they can be controlled by, let's say, the state. Here is a certain problem which I would like to mention. We should not forget that all intellectual property rights, including all those rights managed by CMOs, are private economic rights. Now, if they are private, they belong to certain individuals or private entities, companies, but this means that the states cannot just have an insight into these private rights without any rules how to do this supervision. So the problem is how can, through the law, regulate supervision of collecting management organizations in an adequate manner or appropriate manner, if you wish. So what does it mean? And again, well, Slovenia is part of EU, and this is the reason why I'm a little bit more familiar with EU legislation in this respect. But in my view, there is a very elegant answer is offered by the very already mentioned EU Directive 2014/26. There should be two systems of supervision. One should be internal supervisory system, which must be set up within CMOs themselves. And this system is obligatory provided by this directive, how institutional and organizational framework of CMOS must be in this particular respect organized. This is the subject matter of Articles 4 to 22 of the said directive. In addition, there should be a competent state authority in charge of monitoring compliance of CMOS with law, having the power to impose appropriate sanctions or to take appropriate measures where the provisions of national law have not been complied with. I'm here quoting Article 36, paragraph 3 of the directive to which I'm referring through all the time. So the question is here, how can then the management and the efficiency and the work or activities of CMOs, how they could be improved? I did make a short look into the Uzbekistan copyright and related rights law, which I found on WIPO website in this WIPO Lex. If I'm not mistaken, there are just 3 or 4 articles 59 to 60, somewhere like this, concerning collecting management organizations. So my advice is that the best way to improve the activities is to set up an appropriate framework, legal framework on national level. So for this reason, again, I think that what this directive 2014/26 from EU may be a very useful example how to draft and then eventually adopt such a law. So this is it. I hope I stayed my time limit. Thank you for your attention, and I will be at your disposal then for any question in this respect. But let me also add that apart from being professor in my free time, I have certain experience how to run an IP, national IP office. I was the very first director of Slovenian Intellectual Property Office, and also in charge ex officio, so to say, representing Slovenia in TRIPS Council, WTO, representing Slovenia WIPO, and eventually I was even a staff member of WIPO for 10 years. So much for me from now on. Thank you very much for your attention, and I'm waiting your questions. Thank you.
Rahmat, juda qiziqarli mavzu uchun. Qonunchiligimizdagi kollektiv menejment organizatsiyalarini, ya'ni muallif va turdosh huquqlarni jamoaviy boshqarish tashkilotlarini faolligini oshirish uchun berilgan taklifingiz uchun darhaqiqat bizlardagi hozirgi
As for improvement of collective management. And also the next speaker will be Policy Officer, FAO Regional Office for Europe and Central Asia, Dmitry Zvyagintsev. And his presentation is Geographical Indications in Europe and Central Asia. He will share experience of FAO Regional Office for Europe and Central Asia and plans for 2021 and 2022. Good afternoon, colleagues. I would like to check if you can hear me. Yes, we can. Good afternoon. Thank you for inviting a representative of Regional Office of FAO to your event. And we do understand the main focus of your discussion is mostly legal rather than the one pertaining to interaction with FAO, but we also have the relevant topic, geographical indications, and now we have the area for interaction as part of support to your agency with regards to development of the draft legal document on geographical indications, and I would like to make a short presentation on that. I would like to share my screen, and I'd like to briefly discuss with you the key aspects related to the market capacity. So these are data from the EU assessing the overall European market at some 956 billion euros. That's food products and beverages. And as for GIs, it's 74% or some 54 billion euros. So data suggest an increase by 10 or 15%, so meaning 74 billion euros as of 2020. And as for exports of food products and beverages, so it's 75 billion euros. And as for exports of GIs in EU, it accounts for some 12% or 11 billion euros. So we are showing these numbers to identify some room for development, and I would like to show you one more slide. We understand that in the EU, which we consider as some benchmark, and so we registered 58 products of TSG and 747 of PGIs. And also, I would like to draw your attention to the fact that as for food and beverages industry, so it is quite high here, especially for Italy, Portugal, and Greece. So now we are discussing the share of GIs and the respective national industries. Some 80% of all registered GIs are from Italy, Portugal, and Greece. So let me just note that in Uzbekistan we also see the great capacity with regards to the activities conducted by organization in the region, and they also listed some potential products with GIs. So currently some 60 products are on this list, and in case the law is adopted on GI successfully this year, so pomegranates from Cuba and melons and other products could be potentially registered. And actually, the capacity of the market is quite high, as I said before. And also, in my presentation, I like to focus on several aspects which were highlighted at regional consultations on GIs. So the consultations were conducted in 2017 and 2019 in Budapest for Europe and Central Asia. And I would like to mention the following points. So we can see the great need for institutional cooperation when the law itself and bylaws are being developed. So we encourage the agencies to be as transparent as possible, to interact with other ministries and agencies. So we are referring to the agency, say, supervising agriculture, the Ministry of Agriculture. Its role in promotion of laws, in enforcement of laws will be very important, because the ministry is very interested in agricultural development and development of agricultural areas where geographical indications are essential now. And so we consider them as a tool to develop agricultural areas. We also recommend envisaging various support mechanisms which could be related to compensations for duties, registration fees, and some other types of support related to compensation for costs, say from secretariat to groups of manufacturers at initial stages, because without that support it will be very difficult to initiate associations at early stages. And development of guidelines is very important as well. This is related to development of code of practices, terminologies with specifications that also indicate relationships of products to some areas, climate, air, water, soil, and the links and associations with some properties of products. And as for the food safety considerations, so given traditional food products, which are definitely protected, we need to understand maybe some manufacturing techniques may not be in line with the norms for manufacture of food products. And based on experience of our European colleagues in terms of food safety, there should be some flexibility and an opportunity to deviate from such norms, so manufacturers could comply with the safety rules. So we have the example of the cheese shipwreck produced in Poland, which is produced in such settings, but following the new rules. And of course, the certification system should be outlined in the national context, given the settings in Uzbekistan and interaction between the public and private sectors. We urge you to be as open as possible. Maybe you need to enable the private sector to participate in certification mechanisms using the examples of certification mechanisms available in the EU, and also there are countries where certification is carried out following the laws and legislation adopted by selected ministries and agencies. In addition to that, we also want to highlight identification of mapping mechanisms for products. And also I mentioned activities with that list of 60 products that was compiled. So let me show you the example of Poland, where the mapping was conducted. 1 year later, the ministry received some 1,000 applications from various areas. And roughly, we have some 1,753 products registered on the website. And many of those manufacturers are using now the geographical indications, so they get to that group using GIs. And another important point is development of materials to disseminate this information, and also for tourism, which is important to Uzbekistan. So we need to communicate that information on GIs. And it will be important for local residents and for tourists. Let me give you that example of the postmarks with the cheese manufactured in Poland. Also, I wanted to show you the materials on GIs supported by our office, and in my presentation you will see the links, and I will quickly highlight the main materials. So we produced the report on GIs on Russia, Moldova, Georgia, Kyrgyzstan, and Armenia. It's available in Russian. Also, we developed the guidelines for practitioners on GIs. It's available in English and in Russian. And we have the document on experience of using GIs in Croatia, Poland, and Hungary. Again, the document is available in English and in Russian. And one of the latest documents we have developed is economic assessment of the impact of GIs on development of agricultural areas, and based on case studies describing experience with GIs, and using the case of Colombian coffee and manchega cheese. So we showed that the price of the product with a GI is by some 25% higher compared to prices for other products, standard products. And at the same time, farmers on average get 10 to 15% more compared to those who sell standardized products. So the link is, I will add the link to that study. Thank you. Wishing you a successful conference ahead. Thank you so very much. Definitely geographical indications are quite new concept for us, and the question is what it means, and one of the options to enhance our agriculture, to promote it, is to come up with our national brands. In this regard, we can also refer to the Samarkand bread or Sirdarya melons, watermelons, and their manufacture and subsequent imports also can contribute to establishing that national brand. And subsequent imports and use of GIs in Uzbekistan in the market currently is funded from the state budget, and in late 2019, I guess some 30 GIs have been registered or submitted for registration, and in this regard we closely cooperate with the FAO, and we work together to develop the new law. Taking advantage of this opportunity, I would like to give the floor to our next speaker, a representative of O'Connor Company, Irina Kireva. Irina, I would like to say thank you to you, extend our deepest gratitude, because you really helped us develop the documents, our documents on GIs, and you are a great expert. So she will inform us on the role of GIs and various tools and mechanisms. Thank you very much. Can you hear me well? Yes, we can. You can continue. Thank you. Slides will be shown for your information, or maybe as an additional source of information. Our presentation today will be about geographical indications and places where the goods are produced. In fact, these terms could be used interchangeably, because for Russian speakers, both terms will be correct. when we are discussing protection of intellectual property. Maybe there is some difference, specific difference, as we could see in some countries. Say, if we take a look at the legislation of the European Union and this very trend, so we could understand the difference between the two terms. It was important when we were developing the law, but now I would like to discuss in general that type of intellectual property, how it can really help us develop agriculture in general. What are its specific characteristics if we compare it to other types of intellectual property? I would like to draw your attention to the fact that places of manufacture suggest the links between the products and geographical areas. Maybe there is some there are some specific geographical conditions or climate, and also we are referring to unique ways of manufacture and distinct characteristics. Because these products are so distinct, they have some specific reputation, image, and here I would like to highlight that very moment once again, why it is so important to differentiate between them and trademarks, because they keep saying that both geographical indications and trademarks, in fact, in the market, can enjoy great reputation, and it is essential for us to understand that we have to protect them. That's clear, but how we can differentiate between the two, and why the geographical indications and places of manufacture are important to us to develop the agriculture with regards to brands development. And the difference is that for trademarks, for brands, any name will be important, but when you start your activities as a company, and if you have the trademark, the company should gain that reputation if they produce quality products. And I would like to request your attention. For geographical indications, for places of manufacture, protection is given only when we have some reputation and when the products are well known to most people because they are of specific quality and they have the characteristics similar or identical products will not have, because they are not produced in some specific geographical areas. So we can see this is one of the important indicators. There were a lot of studies, economic and legal, which have demonstrated the specifics of this very type of intellectual property. And one of the studies is shown on the slide, so you can see the link to that study and you can find it in the internet. A very interesting report which has been produced by that center. The main idea was to show that in addition to that special reputation that products have, as mentioned by the previous speaker, the premium price is offered. It means that their price could be higher compared to a regular product, similar product. And various economic analysis show that the difference can reach some 20%, 5, 10, 20%, depending on the type of good. If it's a unique product, and if the consumer is willing to pay extra, then these products can have like some 35 to 40% markup.
So it is quite obvious if we focus ourselves on the place of origin and manufacture, what is the specificity of that? So we specifically determine them. So you see that diagram. So that's the diagram where we have four aspects, and in particular, they are very much correlating with each other. So let us start with the environment and environmental protection. You understand that the quality of the product, can you go back one slide back? So the product quality is different from others just due to the fact that geographic position is different, geographic position of the producer or manufacturer. So indeed, the farmers which are located in that territory, they will be highly interested in for that environment to be preserved in the quality as it is right now, even probably to be improved. Well, but in any case, not to deteriorate. So if we see that there is a deterioration, then, and let's say the soil erosion is there, or other factors which would impact to the climate elements, and the product will not be of that quality anymore. So then this product cannot be protected anymore. That's the logic, that's the rationale. So the high level of interest among the farmers, they are highly interested for this environment to be protected at the proper level. So now let's go to that other part, social data. Why it is so very much important to look into geographic indicators. Those people who produce these products and have great pride of this product to be well known, not only in the country of origin, but also beyond that. Because due to statistics, we see that it's not only local production, but also and consumption, but also it is production for export. So we know the numbers that has been given by the previous speaker, how important it is within the strategy and policy of exporting to present the products with geographic indicators. So it is very much important to have the social data for export. And it's also important for the people who produce that product. They will be still located, residing in that particular area, so which means that there will be decent work, decent job places provided. So we may also say that they will keep developing their business. That's the elements that we are discussing, and we're talking about the element of public authority and the consumers. Consumer dictates, demands what exact product they want to consume. If there is a high interest or demand among the consumers, especially towards those products which are being manufactured within certain geographic locations, so that means that this demand will find a supply. So this demand will be responded by proper supply. It is quite an obvious link of those two components. Last, all the resources. So we are discussing conventional approach. We also discuss different methods specific to certain territories. You know what? All this diagram, when you see all four components or vectors of development in place and the importance of this, and then the place of origin and place of geographic indicator. So besides just geographic indicators and agriculture, what other elements we see as the consequences? Like in Europe, for example, it is tourism that is directly linked with geographic indicators. Similar happens in other countries of the world. People who just visit certain country, and I truly hope that this will happen soon. Recently, it's not happening anymore. There were even touristic routes or traveling routes to visit some winery or other types of like cheese producing factories or any other traditional crafts of certain location that very much attractive for tourists. So we see that besides social data, touristic element is involved. So, and also in general, the whole reputation of the country. So we know about France, right? And there were several examples provided to us. Imagine in France, which is well known with its wine and cheese, for every day of the year, we may have specific cheese. Imagine they have more than 400 types, 365 days. You may every day consume or try a different type of cheese. It speaks for itself, right? So as for another statistic, to what degree economically it is beneficial to produce certain product with denomination of the product you may sell poultry meat, but it could be breast chicken. For the kilo of that chicken, you pay 4 times more comparing to any other like commodity chicken meat. Of course, producers, farmers, they have high interest. Why wouldn't we think, or why wouldn't they think about this type of intellectual property? And what wouldn't you join in to produce this type of product or commodity? And you well aware, you know that finally it will be sold. It's in demand. So you will obtain your income, your profit. This profit, it's not given to last retailer, which is covered by the whole chain of commodity sale. No, it is distributed quite specifically, starting from the primary part. Let's, for example, cheese production. So certain type of cheese will cost 20% higher. So imagine the milk producer for Comté cheese. They get 10% surplus for the milk which they supply in order to produce that type of cheese. So definitely there is a strong stimulus, incentive. So to have geographic indicators, they are impacting the decision to further develop agriculture. So, and they may serve as a very strong instrument to achieve certain objectives. Or you have to work for some time when the trademark will have to start working, you know. So you have to invest to develop the trademark for that to be well known. But if you have geographic indicator, then by itself, it speaks for itself that that's the product with reputation and it's well known. So small and medium business enterprises can join in that regard, in that geographic location to produce certain commodity. Several slides we may check, but this idea, the whole idea behind this presentation is to explain those important elements, how different geographic indicator is with regard to any other intellectual property feature. So like design, for example, we're not only protecting denomination, but the whole product, commodity. If cheese has certain form or shape which makes them different from all others, that will be part of protection of the place of origin. But if any other cheese will be having same shape but will be produced somewhere else, that's the violation of those who legitimately use this geographic indicator as protection. So it means that it provides wider range of protection. So similarly with know-how or patents which they applied in manufacture of certain commodity, that is the comprehensive protection of intellectual property rights, which are covered by the aegis of only one indicator. Another thing, not to mix up things. Simultaneously, you may use the place of origin, but also trademarks. We see it all over. So any bottle of wine or champagne or sparkling. So champagne, that's the place of origin, but you know that there are trademarks which were able to reach certain reputation, and there are certain colors which are applied for the marking. So we may use that in parallel. So, and any other types of intellectual property protection means which will be in need of for us to identify this or that commodity. Quite rapidly, I'd like to cover following slides. I just wanted to show it to you, certain elements of different programs of European Union. One more slide, please. And one more. Like, for example, enjoy European quality or This is for Europe, for Italy. See, what is the budget? What are the programs? How much you would need from European budget, how much you would need from national budget. But all these projects and programs are there, established in order to explain that this is the commodity that we produce. It is of a high quality and that's of a specific characteristics. So how this product should be promoted, that's very much important for brand promotion. So there is time for Apple in Europe. Let's try European quality. You know, we cover all of them. So, but I just want to say that besides European goods, commodities, we also have other countries of the world. Yes, please, more and more. Yeah. So, time to eat apples. We also have promotion of Kenya. So you may just talk about tea from Kenya or coffee from Kenya, but we may also say more specific coffee, like, for example, the mountain of Kenya. So just from the hills of that particular area, they have specific type of coffee, Arabica. So next slide, or previous slides, there were different pictures. You know, Zanzibar. This is very interesting. Slovenia. There was this case on the name of Demarera. So it is being used in many countries. So besides Guyana, they are using that particular word for that brown sugar. So that was the type of sugar, actually. But Guyana said, no, in our country, we protect this product as the place of origin. So that's because that's after the name of the river where they grow this sugarcane. So that's why it's geographic indicator. So right now, this is not only national process, but also European Union protecting this denomination. So for sugar, it's applicable for sugar or any other products. So it is quite specific when we are trying to assess the market. So not all the countries may apply that denomination, even though they thought that it is for the general use. Last slides. I'd like to thank all of you for your great attention that you've expressed to me. Should you have any questions, I'm ready to answer. But my idea was to share with you this difference between geographic, to differentiate properly all other types of intellectual property, how you may apply them to develop agriculture for national programs, and to what degree they may be organically involved, synergically involved when you apply them together with other denominations. Then all other aspects can be properly protected, intellectual property protection rights. Thank you. Mrs. Krieva, thank you so very much for your comprehensive report. Our next speaker of today is the intellectual property expert from Turkish Patent and Trademark Office, our colleague. He will be delivering his presentation on promoting geographical indicators for primary agricultural products in Turkey. And Mrs. Ozden İlhan, I'd like to pass the floor to you.
Okay. Thank you again for providing us this opportunity to talk about geographical indications. My presentation, I thank Ms. Irina, because my presentation will be like a continuation of her presentation, and hers was very, very informative. So I want to thank her first. And I want to start by talking about the protection of GIs in Turkey, a little history about protection of GIs in Turkey. Turkish Patent and Trademark Office is actually established in 1994, and it operates under Ministry of Industry and Technology. and its main aim is to protect industrial property rights, and it is in Ankara. And GIs are protected in Turkey since 1995, but they were protected by a decree law number 555. But this law was not very comprehensive, and there were not many GIs which were registered during that era. But in 2017, new industrial property law, the law number 6769 came into force. And this law was very in line with EU geographical indication protection, and it simplified registering and protecting GIs. So, and also with this law, Department of GIs was established in our office, and now I'm working in this office for since 2017, and right now 20 experts.
I cannot hear anything.
You cannot hear?
I can.
I'm sorry, is the sound not working?
The interpreter is hearing you well. We do hear you well.
Interpretation.
Continue so far.
You can continue.
Yes, please continue.
I briefly talked about the protection of GIs. It's in the slides as well. And which GIs are protected in Turkey is a little bit different from EU. The food agricultural GIs are of course protected, but unlike EU, we also protect mining materials, handicrafts, and some special industrial products which can be registered. A little about registration process. The first submission of application is sent to our office, and the application fees and registration fees are very small. They're mostly small amounts. And after the application is provided, it is examined by our office, and any rectification of errors are made. And if it is necessary, we request for expert opinions from Ministry of Agriculture or Ministry of Culture. And then if the application is found sufficient, it is published in our official bulletin, and there is a 3-month opposition period. After, if there is no oppositions are filed, the product is registered as a geographical indication. And in 2018, at the beginning of 2018, the emblem regulation was published, and it was entered into force. You can see these 3 emblems are official emblems for GIs in Turkey, and it is mandatory to use these emblems with the name of the indication, with the geographical indication. Here, the red one is PDO, the green one is PGI, and the blue one is for traditional specialty guaranteed. And a little about what are the sanctions for the improper use of official use of GIs. The controls are actually carried out by a control authority, which is specified in the application, and it is approved by our office. So the applicant specifies the control authority, and this control authority carries out controls, and if there is any direct or indirect use of the GI or the emblem and on the products which do not meet the product properties in the registered, this is considered an improper use of GI. Any use of style, type, method kind of indication is also considered the improper use of GI, and the control authority or anyone who has the right to use the GI may file a lawsuit against these improper uses of this GI. And the following can be claimed from the court. Of course, the most important is to stop the infringement actions and to ask for material damages from the company or the producer who is using the GI improperly. You can request to seize the products which are causing infringement. Also, you can ask to be granted property on these products or devices, or even the machines which are used to produce these products, and also ask for measures to prevent continuity of infringement. Here you can see a little graph on the number of applications and registrations of GIs in Turkey, and you can here clearly see before 2017 there weren't many applications or registrations, but after the new law, there was a huge increase in popularity of GIs. Also, there were many promotions with the coming of the new legislation. And last year, even though there was the pandemic and most of us were working from home, we had a record number of applications. So right now, we have around 700 registered GIs in Turkey. The product groups are here. You can see the highest product group is the processed and unprocessed fruits, vegetables, and mushrooms. And of course, this is today's topic for me, and I will be talking more about this. It is actually, you can see, this is very well expected because agricultural production in Turkey is quite high, and Turkey is one of the biggest producers of fruit and vegetables. Although it's a small country compared to the other bigger countries, it is very fertile and it has a very favorable weather conditions for growth of fruit and vegetables. So you can see here that Turkey is the 6th biggest producer of fresh fruit and 3rd biggest producer of fresh vegetables in the world. And it is expected that there are many special fruit and vegetable products which are produced in our country, and right now they are in the process of being protected as geographical indications. And of course, I will be talking about promoting GIs for primary agricultural products. And there is actually a need for this in our country, because even though the agricultural production for fruit and vegetable products is very high, the value chain is not in the favor of the primary producers right now. It is one of the main topics in our country's economy right now, trying to bridge the gap between the price of the product in the field and the price of the product in the market. And what GI protection does is to create a competitive tool for the producers on the market. So it is often hard for the producers to create a trademark for their products, especially for agricultural products, because agricultural products are often sold without trademarks. And in most places in the world, they are sold without any packaging as well, usually without packaging, or very minimal packaging. And this provides, the geographical indication provides a very distinct tool for identifying these fruit and vegetable products and a sign for quality. And these emblems also can be used as an official quality guarantee symbol for the fruit and vegetable products. And there is actually a preference from the consumer side for high quality and unique products. And geographical indications has this better connection with the place, and they can reach these niche markets. And some products are very unique, and these products are often have also some buyers which are very interested in these products. But because these products are unique and often produced in very small places, smaller producers are quite have a hard time reaching big markets. And in many studies carried out on geographical indications, it is often shown that smaller producers can have better performance of their GIs compared to bigger producers, because they can have direct sales, which can have a lot of profit. Normally, if you think about this, is an Apple product from north of Turkey, and this product has this red inside. Inside is red. But before the GI production, this apple was sold as a conventional apple in the markets and nearly the same price. But right now it is sought after by many retail shops, and it is sold for much higher prices because it is a special product. And this higher profit margins, of course, creates a development of rural economy. Also, the GI label could help the smaller producers to achieve higher incomes. Often, right now, for some GI products which are highly sought after, the farmers often make contracts with retailers, and the contracts are made for guaranteed sales. So they will have their money before they produce their product. So which is a very good thing for the producer. They do not have to worry about selling their product. And you can see here the retail sales are also have a higher profit margin. This is a conventional bean, a dried bean, which as you can see here sold for this price, and ispir beans, which are a GI product in Turkey. Even though it's a lower weight, it is sold for nearly twice the price of this product. So it's a very high quality GI product, and it causes significant profit. And of course, the geographical indication primarily indicates a higher quality, and this higher quality is seen by the consumers as a willingness to pay more. So they are willing to pay more for the quality which entails this GI product. And you can see that also has this higher added value. And I also compared, this is a very recent, I took from the online shop, from our biggest retailers in Turkey. A standard orange is sold for 3 liras, and but the PDO Finike orange, it is produced here in these orchards. This is Finike city. It's a city very popular for producing oranges. It is sold nearly 3 times the price here, you can see. Also, these GI products have easier access to food retail. Here you can see some very known trademarked brands, very known brandings. They use this GI tag to also create a differentiation of their products. And of course, they are buying this product from the producers, which is another income for the producer. Also, we are working as our department of Commerce is working on a new legislation on retail outlets, which will entail a quota on GI products, which would entail like 1% or I don't know the exact number right now, but there will be a quota on number of GI products which must be sold in all retail shops. So the retailers must have some GI products sold in their shops with this new legislation. So it will give an easier access to food retail. Also, in our country, there are many product festivals and events which are specifically done for GI products, and this creates a lot of free publicity and access to broadcast networks. You can see here, this is from Finike Orange Festival. All the city is covered in oranges, and also this tomato product, Boyabat domatesi, a farmer contest for the best tomato. Also, a very popular event is our artichoke festival in Urla, which was so popular that the 3 cities in this region were all booked. All the hotels in this region were booked. And there was nearly 1 million people who came in that place around that time, it is said. There are also some fairs which can be arranged for GI products, which also creates an opportunity for producers to promote their products. Here you can see the 2 biggest fairs in our country. The first is the Ankara GI Summit, which is done every 2 years, and Eurex Summit in Antalya, which is held every year. And these are very big events which create an opportunity for producers. Also, for agricultural products, there is an ex officio protection by the GIs, for the GIs by the Ministry of Agriculture and Forestry. This also creates a level of trust by the consumers. So if they see this branding here, they know that it is further controlled by our Ministry of Agriculture and Forestry. So I thank you for your attention. And if you have any questions or more detailed questions, if you like to ask about the Turkish system, please contact me on my email. So I will stop share.
Rahmat katta Ilhom xonim. Reglamentimizni hisobga olgan holda savol javoplarimizga juda kamroq vaqt qolyapti. Shuning uchun
Unfortunately, we have very little time for discussions, questions, and answers. So if you have questions, please try to be brief. Any questions to our speakers, please? Dear participants of our today's event, dear speakers, thank you so very much for your interesting presentations. And my question is about protection of IP rights. International experience, as you're aware, also suggests the concept of parallel input. So when the holder, as a holder of such rights, you can also import authentic regional products. And under TRIPS, you also have the concept of ex officio as a standard. And it is mostly about activities of customs agencies, and customs agencies use their resources and powers, and that they can prevent potential imports of counterfeit products violating IP rights. So parallel import to European countries, to what extent it is an infringement, and if so, and about goods imported under parallel imports, do you use ex officio protection, ex officio procedures for such products? Thank you very much, dear speakers. Who wants to answer this question? I hope that question was clear to you. Parallel import and use of ex officio for parallel imports.
marhamat.
If I may. Yeah. For parallel importation, which is the international 6 of the TRIPS agreement. And so the TRIPS agreement do not interfere whether the national legislation would allow parallel importation or prohibit parallel importation. So the answer would depend very much on what is the national legislation is saying in this point. As for the TRIPS agreement, they do not interfere. So if the national law, let's say in the case of trademark or copyright, prohibit parallel importation, then and also allow for ex officio by the custom department, then the custom department can seize the goods. So this would depend, as I said, very much on the national law of Uzbekistan. Thank you.
Rahmat. 2017-yilga tegishli ravishda qonunchiligimizga o'zgartirish kiritilgan va milliy qonunchilik.
In our national legislation, there are no barriers. One more question. Dear participants, dear speakers, thank you for your presentations. My question is, for example, detection of counterfeit products and the business entities producing counterfeit products. What mechanisms do you use to hold them liable? If it is a business entity or an individual, in our case, it's like this. Experts give their opinions. If there are attempts at counterfeiting brand trademark, then the sanctions penalties shall be applied. And if an agency produces counterfeit products, the producer is saying to what extent there are similarities. Are there any criteria, like it is similar by 5%, 10%, and the like? So when you are detecting counterfeit products, do you have any criteria, like percentage-wise, to what extent the products are similar? How can you identify that? I think Samir Al-Taravneh, so you were discussing counterfeit products. We would like to hear from you, please.
Sure. This was referred to by Article 61 of the TRIPS Agreement and Article 51 also of the TRIPS Agreement. 60 is related to criminal procedures, 51 is related to border measures. As I said, it's very important to define counterfeit trademark or copyright pirated. There is a huge difference between infringement of trademark, where in this case you might discuss similarity or not. But however, in the case of counterfeit, I will read the definition provided by footnote 14. It says, shall mean any goods including, without authorization, a trademark which is identical to the trademark validly registered in respect of such goods, or which cannot be distinguished in its essential aspect from such a trademark. As you can see, either identical or cannot be distinguished. So the question of similarity when it comes to counterfeit trademark, according to TRIPS and according to the dispute resolution decision between the United States and China, there is no question of similarity. It's either identical or cannot be distinguished. So similarity or not does not exist in the counterfeit of trademark. This is from the international, let's say, this based on the TRIPS agreement. However, based on our experience, that we noticed that many countries, they do criminalize a simple infringement of trademarks. So again, this would depend on national legislation, and if the national legislation extend the criminal procedures to infringement of trademarks, then the decision whether this trademark confuse the public or not. I don't think there's a case of a percentage here, because trademark infringement depend very much whether the public is confused by sound, by the way you pronounce the trademark, or the way you write the trademark. To make it a bit clearer by an example, you might, everyone knows the trademark Nike. However, if you write it N-I-K without E, the pronunciation still is similar. Then there is an infringement and there is a counterfeit. So this, as I said, would depend very much how how you extend criminal procedures to trademark or to copyright. According to TRIPS, is very much limited to the case where there is an identical trademark or the other trademark cannot be distinguished, which is close to identical also. So in this case, you don't have any problem, whether in the customs or in the court, compare with the case of infringement. I hope I answered your question.
Rahmat, menimcha juda to'g'ri va to'liq javob bo'ldi.
Yeah, I agree that the response was quite full and proper.
We know that nowadays majority of small and medium-sized companies are copying the most popular trademarks in order to boost their sales. So my question is there any relationship between the functionality of the trademarks and the performance of small and medium-sized enterprises? Thank you in advance.
Marhamat.
Yes, please.
First of all, we have to agree that a trademark is similar to a passport. It's an identity of the products. And the more people they have confidence on the trademark, the more they don't really examine anymore the products. So you go buy a product because you do believe and you have a confidence in this trademark that it poses or it includes a minimum certain of quality. That's why you buy the products. Counterfeiters, of course, they take advantage of this, that people, honestly, they don't examine the products anymore. Once the trademark is there, they buy the relation between the trademark and the products and counterfeiter. Did I make myself clear again?
Rahmat. Oxirgi savolni beradigan
Last question. All the rest questions you may submit to us, and then we will also submit them to the experts, please. Good afternoon, distinguished participants. I'd like to ask a question to the madam from Turkey. I have a question, if I understood you correctly. You've mentioned that local population, which is producing food products, those are the bakery commodity and sweets which are not sold in the specialized shops, but in the open area like tulum, simit. So you've mentioned that they are also being marked, and specifically you provide them with certain marking or labeling with the quality mark. My question is, could you explain, maybe I misunderstood you, how do you do this? How do you register that in the legislation of Turkey? How do you protect them, if I was able to explain it to you? Was it clear?
About like
how do you assign
we have 4 different types of applicants, actually. Either governmental organizations can apply for a geographical indication, a producer group can apply, or a foundation or a trade group which do not have profit from producing these products can apply for GI protection. So these applicants first create a dossier, like a file, application file, and it is first submitted to our office. And we examine this, and then if the product has the characteristics which are necessary for a GI, like a link with the geographical area, a certain characteristics which make them unique, these type of characteristics, then we publish it and then register it. The product itself, it is not, it doesn't have to be a packaged product. It can be sold as it is. If I'm answering correctly, please, if it's not what you're asking.
Rahmat.
No, thank you. Thank you very much. You've answered, you've responded well. If I may, I would like to add. Yes, please. I understood your question this way. If they're sold without packaging, how may we understand that that product is protected or not? Imagine you are selling just part of a big, like huge piece of cheese, and then marking is only located on the bigger part. Number two, if you're selling apples, as it has been already mentioned, from a big package. So on the package, you have this marking, and all accompanying documentation will be provided to you when needed, when you request that. But my Turkish colleague has responded well. So, but the products can be sold in bulk. So if you bought it bulk, then you won't probably see that marking. But sometimes on watermelons, on melons, you see certain stickers. Maybe on apples, you could see this little stickers, or oranges, but on nuts, for example, it's impossible. But if you see the bigger packaging material, then you would see that mark. That's how I would like to clarify. Of course, you see that down to the very last moment that this product is sold under the coverage of that protection system, certification quality system. One more thing with regards to trademarks and counterfeit products or commodity. They are different from GI, right? You remember that. And protection here in European Union is a lot, goes very far beyond than it is covered by TRIPS. It is TRIPS plus. So imagine, it's not just a practical implementation with some similar denomination is there in translation or the style or methodology of producing, like in Champagne or Burgundy. So even if you're trying to apply or imitate the shape of the product, it is the violation of the rights of the trademark owner. So expertise. Well, it's not that we are finding out the degree of similarity. No, me, the producer, I'm stating that your product violates my rights, that you may, it is a deception, so you may puzzle the consumer. See how strong a protection is for the GI comparing with trademarks. This is what I wanted to comment on. Thank you. Thank you very much. My apology that I...
Now I understand better. Here, what you can do in these sliced or packaged products is you have some options. First, you can actually prevent from the sellers from slicing your products. You can make them only sell the product in its original packaging. So only in the geographical area, the slicing or the packaging can be done. So this is one way of protecting. And there is another way, which is the traceability. So if this company has bought, let's say, 100 kilograms of apricots, but sold 150 kilograms of this GI apricot. So there is this 500 kilos of difference. So if you look at the sales, the sale receipts from the producer of the GI product and look at the market's sales receipts and find a gap, then you can certainly file a lawsuit about this, because they have sold this product more than they have bought from the GI producer. So there you have some options on this. Thank you.
Rahmat.
Thank you very much. Well, I would like to congratulate everyone with upcoming Day of Intellectual Property. I naturally think that our session was quite successful. I would like to thank everyone, and I'm thankful to all the participants. Great you. I truly want you to be successful in your endeavors. Thank you very much.